First zoning hearing board of Radnor Township. We have 4 matters for tonight. We had 5 on the agenda. Matter 2941 has been withdrawn, which is 125 Bloomingdale Avenue. So if you happen to be here for that, you can go home, unless you feel like watching. Our first matter tonight is Appeal 2939. The applicants Kenneth G. Barringer and Elizabeth W. Weber, property located at 411 Luella Avenue and zoned R1. Seek a variance from restrictions of zoning code 28015D1 to allow aggregate side yards of 34.3 feet, a variance from the restrictions of code 28015F to allow impervious coverage of 28.46%, and a variance from 280.112D to allow expansion of a driveway backup area where there are steep slopes. In the alternative, the applicants contend that the proposed improvements are allowed by right.
Evening.
Good evening.
Nicholas Cornelia representing the applicant, and Norm Olson.
And Barringer.
Yes, it is.
Kenneth G. Barringer.
Elizabeth Weber.
And just to go over the board, that's on. Yeah, leave it on. So, yeah, you're going to use it. What I've marked, there's a list of exhibits, and I'll go through them as we're going through. You don't have them marked. I did mark a file copy for you. And this is A14, which is really the existing conditions and the proposed conditions. This is an area that is zoned R1. This lot is really an R2 lot, and you'll see that it was created as an R2 lot back years ago. The rezoning of this area took place probably in the early 1990s. There's several large lots in the area, and it was determined rather than have them subdivided that we would rezone the area. The problem, of course, when you rezone anything is that you created a bunch of nonconformities. This is A14. And this is one of the lots that was created by the nonconformity. I have a copy of the zoning map that I will show you also to show how it was carved out. It's a peculiar lot, as you can see. It doesn't conform to the lot area requirements. It doesn't conform to the lot width requirements, in particular as to where the current house is located back in this corner. The lot width is only about 80 feet. The code requires 100 feet at the building line, but because the building's set so far back that it is non-conforming as to the width. The relief that we're requesting is relief from the aggregate side yards. You'll notice we have a very small side yard on one side, which we're not increasing. We also have a non-conforming rear yard that we're not increasing. And actually, we're keeping the 25-foot requirement on the left side of the building as you're looking at. I guess it would be the north side of the building. But when you add the aggregate together, we are increasing the nonconformity regarding the aggregate side yard, even though we are still keeping 25 feet on that side. The current lot is nonconforming as to the aggregate side yard. This would be increasing that nonconformity. The other relief that we are requesting is the impervious coverage relief, because I mentioned this lot would conform. This was zoned R2. This would conform to the impervious coverage requirements. Currently, there is no at all. There's nothing here regarding stormwater management. The proposed development will require full stormwater management in accordance with current township regulations. As I mentioned, there is currently no stormwater management on the site as it exists. We would need a variance from the R1 requirement for impervious coverage, but as I mentioned to you, that we would conform with, if this was still zoned R2, it would conform with the impervious coverage requirement. So as I mentioned, it's a number of existing nonconformities, and I'll introduce the Barringers and ask them some questions, and we'll proceed.
You propose to install stormwater management as part of this project?
Yes, it will be required by the township because more than 500 additional feet is being installed, and they will comply with all township codes regarding stormwater management.
and be satisfactory to the township engineer?
Yes, that is correct. Ken, you're the owner of the property with your wife?
Yes.
Okay, and you purchased it, first I've made the application, Exhibit A1, for the board, and then A2 is a copy of the deed, and you purchased the property in September of 2014.
That's correct.
Correct? Where do you currently live?
We live on Midland Avenue.
Are you moving from the Midland Avenue site to this site?
After redevelop it, yes.
Okay, and who will be moving there with you?
My wife, myself, and my 2 children.
Okay. I've marked as there's 2 old zoning opinions in the application. One is appeal number 1268. And really the significance of this is this was a carriage house at one time. And if you look at the pictures, you'll see that it looks like an old carriage house. It was subdivided off, I believe, initially, if you look at 1268, 3 lots were created from it under the R2, then R2 zoning. This appeal was from 1975. And basically, it just confirmed that you are allowed to have nonconformities regarding setbacks when you do a subdivision, and then there is some case law cited in there. The other appeal number is 1356. I marked that as A4, and that was a request for an underground garage. It was going to be within 3 feet of the property line. And Ken, was that underground garage installed? My first question, was it installed?
They built one.
Okay, and is it 3 feet from the property line?
No.
How far is it?
It is 22 feet.
Okay, so actually they got relief, but it didn't look like they acted
Don't
on it.
understand why, but no.
Okay. I've marked as A5, and I just put in a record copy. So there is a record copy of this, but you do not have, the board members do not have a copy. I'll hand it out. And the reason for this, you'll see the light yellow portion. That is the R1 zoning district. It is surrounded by the light green, which is R2, and you'll notice there's smaller lots in the R2. And then the darker yellow is R3 zoning, which again has small lots. But if you notice, the area that was rezoned R1 does have several larger lots. And as I mentioned, unfortunately, I go back remembering when this was created, and it was created so that these larger lots could not be further subdivided. So A5 is just a copy of the current zoning map indicating the zoning and how this R1 area was carved out of previously R2 zoning district. I've also had some pictures that I'll ask Ken to identify. The first one I've marked is A6, and that's the one, the top picture says 411 Luella from Street.
411. 411.
Yeah, 411 Luella from
That's
the
our
street.
property standing on the street. You barely see it.
Okay. And then 411 from street of driveway, again, basically indicating you can't see the property from Luella
Not
Avenue.
much.
A7 I've marked, the first top picture says 411 Luella Avenue North, and this is the existing structure?
That is correct.
All right, now, you're obviously intending to put an addition on the structure, but from a design standpoint, and we'll get into that a little bit later, from a facade standpoint, how are you intending to keep the historic nature here, and what are you intending to do?
We're trying to keep the historic parts of it. It was modified in the 70s and sort of poorly done, not in the style of the 1905. So we're trying to renovate that, replace the windows, make it look like it belongs. We've got an elevation of it.
Yeah, that we'll
You can
introduce.
take a look at it if you like.
Okay. And you mentioned, when was this building built? This
We believe
correction?
1905.
All right, so it predated any zoning in Radnor Township? Okay, well,
you can answer
the
that.
zoning code was, I think, created in 1928. A8, it says 411 Luella Avenue South. Again, these are just views of the existing
Correct.
home. What kind of, is it any state of disrepair now, or what kind of condition is it in?
Not great. Not great. The shakes are worn out. The The second floor dormer in the back is just purely plywood. There's no finish on it at all. It's pretty much like an old barn.
Okay, and 8-9, I believe, shows some views of neighbors, 407 Luella, is that what
That's correct.
And that's showing from your property?
That's from standing in the middle of 411, looking north.
Okay, and we actually have a letter of support from 407, from the tags who reside at 407.
Right.
And I'll hand that up also. And then 810, again, is 407 from the street. Again, it shows, or what are the homes in this area? Are they large? How would you describe them?
Oh, they're large.
Okay.
Yeah, they're many larger than we're going to build.
All right. And again, 407 is the top picture I marked as 810, and 439. That also appears to be a relatively large home as well. Is that correct?
Yes, it is.
Then I've marked as A11. I believe there are two homes on Pembroke. Again, it's just showing the neighboring property.
That's all on one property behind us.
Okay, so the Pembroke is actually the road behind you.
That's correct.
All right. And this is a garage here on the bottom picture of A11?
That is a carriage house, or
Okay.
garage that they built.
All
Yes.
right. Then A12 shows 211 Orchard, again, a neighbor behind you.
That's correct. That's an old carriage house, too.
And A13 shows 428 Luella from the street and 424 Luella from the street,
Correct.
right?
Across Luella.
Again, pretty large homes.
Good size.
Now, I'll mark as A15, and I'll hand this up. I don't know how many copies we have, but A15 is a renovation and addition. First, did you have to go to Harb because this is in the South Wayne Historic District?
Absolutely.
And you went to Harb and you got permission from
Yes,
Harb?
yes, we did.
And-
These are the same drawings we submitted to Harb.
And the Board of Commissioners have approved?
That's correct.
Okay. And these are the same drawings, it said again, showing A14, it says sheet 4 of 8, but this shows both the east rear and the west front elevation,
Yes,
and it's very consistent with what you're proposing here.
absolutely.
And then sheet 5 of 8 refers to a southern elevation and a northern elevation. The southern elevation shows a garage as well as the addition itself,
Correct.
correct? And then the northern elevation too, correct?
Yes.
And you got the Harb approval, so you will build this in accordance with the plans that were submitted to Harb.
That's our expectation.
And that's all A15?
That is A15, and I'll hand this up as
Okay,
exhibit.
that can,
Now, a mark is A16, and these are some support letters, and I believe there's maybe some more in the file, I'm not positive, but the ones that I'll hand up are from the Teggs, who reside at 407 Luella, the Pressmans, who reside at 222 Upland, and the Taylors, who reside at 439 Luella. And I believe there are two other ones that I have here. One is from Adele Olivia, and she's 331 Luella, and I'll just mark that as A17. And then from the Carneys, and they're 211 Orchard.
Mr. Cornelia, we have a email letter which was signed, so we can admit it, of support from who do we have here? Julia Bonenberger. And what do you, are we labeling all the letters of support?
It doesn't, Mr. Ryan, I really, if you want to label them, it's fine. If not, it's okay.
They're all of the letters collectively are A16.
A16.
Okay, that's fine. We'll do that.
Okay.
Though you may want to correct, I think I labeled one A17 and A17.
Okay.
They just make them.
Now, just looking at A14 as to the proposed conditions, again, the site plan shows proposed conditions. It shows that we're keeping that 25-foot side yard setback, correct?
That is correct.
And there's some other relief requested. We requested some relief from the steep slope requirements. Is that right?
Yes.
And is that in this little shaded area that you see here and here?
And a little bit there.
Okay, and what are you disturbing there?
It's a small little bank that was beside the garage. The garage was set at maybe about 4 feet underground, and there's a slope on either side of the garage that I don't know if they built or was there. I really have no idea. But we want to shave that off to get part of the parking area and driveway.
Okay, are you affecting any sort of soil subsidence or anything of that nature by
No,
shaving it off?
no.
It's very minor what you're doing?
It's very minor. It's got some timber walls there. They're 3 feet
I
high.
think you mentioned you had some photographs that
I
did not
do.
have part of the record.
I do. Let me just hand them up to them.
Let me mark them first. And you only have one copy of these, I guess, right? Okay. I'm going to mark them, all three of them as A17. And if you can just tell the board what the first A17 represents. It looks like that's that garage that we were referring to.
This is the garage.
previously.
This is standing on the south line of the property, and you can see there's just a small wall to hold the dirt around the garage doors, and it doesn't come up more than 4 or 5 feet on either side of the garage as it works back.
And you're shaving into that a little bit? Are you still use a retaining wall there, do you know, or you be able to grade it?
I think we're just going to grade it so,
Okay.
and vegetate it so it doesn't do anything.
And then is this A17 kind of another photograph of that?
That's the east side of the garage. This is both sides. This is the same east side.
Right.
And then there's one of the west side.
And that's the one on the west side, just
Correct.
closer views?
Correct.
Okay. And we had mentioned regarding the impervious coverage requirement, and actually, you're at 28.46, correct? Yes. Which would require relief from the 22% required by current R1. According to the plan, you're slightly over on the impervious coverage already. You're at 22.8%.
Correct.
All right. But you are less than the 30% that would be R2 zoning.
That is correct.
That's all the questions I would have at this time.
Mr. Cornelia, are there other locations on the plan where steep slopes are implicated?
The only other location, there's a location, as you'll notice, the crosshatched portion here. There are slopes that are between 15 and 20 that we just have to show, but are not covered by code. And there's another crosshatched portion up in this area that, again, is less than 20%, and all we have to control is steep slopes greater than 20%.
And is any portion of that patio that you just pointed to in a 20% steep slope?
No, it's not. Oh, it is, I'm sorry.
Right.
It is, I'm sorry.
Might be a little bit.
So do you
there's a
have
little
any,
bit there.
you have any photographs of that or any discussion as to why you need that relief there? Because, I mean, it's a patio. Yeah, it's a driveway also, but it's also a patio. So is there any discussion of that you'd care to offer?
I don't know if you have, do you have photo of that?
I don't have a photo of that spot. There's nothing there now. It's just lawn.
That's okay.
Yeah.
I mean, it's our intention to be able to have some outdoor space, and it's very minimal. I mean, quite frankly, not as large as we would want, but we're trying to be mindful of, the neighbor and the space, and so that is, would fit a table and not a ton more.
We're intending to stay at grade there, not, we're not building it up or anything.
But to construct that patio, you'll be moving some earth in those areas, presumably to level it out, unless, like that TV ad that's on now, the house that's tilted this way,
There's some amount of dirt you move, sure.
And how will the slope be retained? Because that slope comes towards the proposed addition,
It
correct?
does, it does.
Okay.
The belief is just some vegetation, regrade it, regrass it. It's not much of a slope there, really. It just gently rises.
It's 20%.
Yeah. Yes.
Yeah, I had a question on the, let's talk about the side yards a little bit. What is the existing aggregate now? It's 41, is that what it is?
It is 31.9 plus 9.3, so it's, 41, exactly 41.
Okay, so with the addition, that nonconformance is going up by an additional 7 feet or so?
Correct. It's
Being-
going
yeah,
up
The nonconformity is
34.
being increased by 7 feet.
The nonconformity is being increased by 7 feet,
All right,
correct.
so the proposed addition, if, let's just say, if we could just shift it over 7 feet, there really wouldn't be any increase in the nonconformity.
That would
Is
be,
that correct?
that would be accurate from a number standpoint.
Right.
As to the house itself,
From
how
a
does it
design
affect your
point of
house?
view, it's a problem if we bring that over, we lose the front of that whole wing that's there now, the existing structure.
Right.
There's windows, there's a dormer up there. You cover that up and you end up with a big tunnel.
Show the picture. Which one would it be?
The front here at the bottom,
We're referring to A7, where it says
A7.
411 Avenue
you'll
West.
see the,
That's the front you're pointing to?
you see the piece in the front right here.
Yeah, okay.
If you shift that over, you're over in front of this dormer, you basically slid it over about 6 or 7 feet off the other side of the house, and you lose all that exterior wall space. It just, we're trying to maintain that look of the house, and the dormers, they're going to look a little different than that, but in terms of, cedar shingle and windows are getting changed
Right.
to be historically correct.
And the neighbor would be most affected by that would be, looking at the picture, the neighbor on the left-hand side. If looking at the
That's,
picture.
yeah, the TEG property.
Yeah. We have a letter from
The tags
them.
probably won't see much of it because there's a row of hemlocks along here, and he sits up a little higher.
Uh-huh.
And he's got plantings along his parking area there. You probably see it more from the south side, if anything.
Okay, thank you.
Nick, how would you articulate the hardship?
The hardship is, we actually do have a lot here that is physically non-conforming in many regards. So we have a lot that's non-conforming as to lot area, a lot that's non-conforming as to building width. You have a lot that really R2 zoning requires 20,000 square feet. This lot is 20,734 square feet, so it barely complies even with R2 zoning. And you also have a lot where the house is located in the rear of the lot, where you have nonconformities as to rear yard setback, the southern side yard setback, and as we mentioned already, the aggregate. And you have a very narrow lot here as well, since it's only approximately 80 feet across this area, where even the R2 zoning requires 100 feet, and R1 zoning requires 120 feet. So in that regards, I believe that you're denying a reasonable use of the property due to the physical configuration of the lot and where this house, which was built back in the early 1900s, is located.
Mr. Chairman, could we check and see if there are other folks who want to speak to this application?
Not yet.
Okay.
Yeah. To me, it seems like you have a lot of, if I was the second former chairman here, he would never let impervious go. I don't know if we're that strict anymore, but it seems like a lot of your impervious is in the driveway. Have you thought about different materials to try to make it pervious so you had less of an issue? Because as you know, we have a major stormwater issue in our township.
We do, and we intend to do full stormwater management as we're required to. The part of the space problem of the driveway is it's very narrow out here, and we don't really want to be backing out of the driveway or backing into the driveway. We want to be able to turn around and drive out. So you need enough space down there to turn around. We've got a daughter who's 14, and not too long after this gets done, we'll be driving, and I'd like to give her a little space to do it without running over anything. But pervious paving seems to not be very accepted in Radnor. We still consider gravel driveways impervious, and you know.
Actually, Ken, you're a builder. We should help people.
I am. You know, when gravel's not pervious, then you know it's pretty hard to get a pervious paving surface that is accepted, I think. We'd be open to the concept, but I'm not aware that Radnor's accepting anything in that way yet.
Give you credit for it, but we can agree to do it.
All right, does anyone else have any other questions? Anyone else? Is there anyone here who would like to come forward and speak on the matter? That makes it simple. Any discussion? Or would someone like to make a motion?
I'll make a motion that we grant the variance from the code requirements relating to side yard and impervious coverage of only to the extent is required and consistent with the plan presented as proposed conditions on Exhibit 14.
We have a second?
I'll second.
Is there any discussion? All in favor?
Aye.
Yep, sorry.
Do you want to add the requirement, which you're going to do anyway, that they put in stormwater management that's required by code and also satisfactory to the township engineer?
Is there any particular incremental legal significance to including that in our action?
I mean, they have to do it.
They have to.
By
I don't
code.
know about the satisfaction of the township engineer.
I did, when I had to build my house.
Yeah, you do it whether it's in the
You
code
do it
or
whether
not,
you-
just
yeah.
do
We
it.
don't get it approved
Then
without
I withdraw the motion.
Okay, right. So as is. So all in favor?
Aye.
Any against? Abstentions? Congratulations.
Thank you.
The next matter is Appeal 2942, the applicant TGR LLC, property located at 812-822 Glenbrook Avenue and 214 Bryn Mawr Avenue, Zone C1, seeks an special exception pursuant to Section 280-101A1 or Section 280-101A2 to construct apartments on the site. In the alternative, the applicant seeks a variance from Section 280-47. The applicant is reducing the existing nonconformity in regards to the number of parking spaces. Applicant contends that no relief is required, but in the alternative requests a variance from 280-103B and a special exception or variance from 280-105F. Applicant further seeks any other zoning or alternative relief required pursuant to the plans presented with the application. You're back.
I'm back. Again, for the record, Nicholas Cornelia representing the applicant, and we'll probably have 3 witnesses. So Norma, you want to swear them in?
You want to call the first one up, or do
You
them
want to
all
call
at
the first
once?
one? Yeah, you can just call the first one.
Okay, just
Yeah,
call
go
the
from
first
there. Okay.
Who's that going to be?
Tim.
And sir, if you'll raise your right hand, I'll swear you. When you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes.
State your full name, please, and spell it.
Timothy Richard Rubin,
Last name.
R-U-B-I-N.
This This application is for properties currently owned by Mainline Health. You may be familiar with it. This site is at the corner, it's right across the street from the Wawa on Bryn Mawr Avenue. And it is if you look at the street here on Glenbrook, the Mainline Health, I don't know if that's the thrift shop there now, or that white building is located in that area. And I think we may, yeah. Why don't we look at it earlier? Okay. Here's the site, and Tim will go through this. County Line Road, remember that recently has been redirected to some extent. Bryn Mawr Hospital over here, the thrift shop here, the P&W, or I guess they call it the R100, located here. Here is the Bryn Mawr P&W R100 train station here, the SEPTA parking lot, and the municipal parking lot. There's a Radnor municipal parking lot in this location here, and then there's also metered street parking down Glenbrook Avenue for quite a distance. As I mentioned, this site is across the street from the Wawa. We have some photographs here, relatively close distance, walking distance to the Bryn Mawr train station, and of course you have the Bryn Mawr R100 stop right behind, or almost right next to the site. As to some photographs, just to familiarize yourself with the site. Okay, I believe these are already marked as exhibits, but again, maybe we'll go through them again as through exhibits. The buildings are in a relatively state of disrepair, as you can see now. They haven't been occupied for several years. The bottom portion of the buildings on Glenbrook were used as commercial space, whether retail or office. On top of those, as you can see, are apartments, kind of similar to downtown Wayne, where you have the retail type use and then apartments on top of that retail type use. This is zone C1, so the residential use is not permitted in this zoning district. In the front three buildings, certainly there is a nonconformity regarding the residential apartment use, as you can see here, and in this building over here, 820, first is 816, 818 Glenbrook, and then 820, 822 Glenbrook. And then you'll see 214 Bryn Mawr Avenue, which is the one far to the right on this map. And it has an appearance of a house, and probably at one time it was a house, but more recently at least, again, this is zone C1. It was used, I believe, as a drop-off point for Bryn Mawr Hospital, as far as we know, again, for the thrift shop. So when it comes down to it, we have non-conforming uses on Glenbrook, and we have a very, very difficult commercial use that we'll get into on 214 on 214 Bryn Mawr Avenue. So we'll start with Tim. Tim, what is your relationship to the applicant, TGR LLC?
Managing member.
Okay, and where do you live?
I live in Chester County, in Willistown.
All right. And you have these 4 properties referred to here, all under agreement of sale with Mainline Health?
Yes.
Okay, and I believe we've marked that agreement. Well, first, I believe as A1 is the application. These have all been pre-marked. A2 are the site information from Delaware County, as well as the deeds are attached to A2A, and A2B is the redacted agreement of sale for the property, correct?
Correct.
Now, looking at A3, you've already described the surrounding area, but why don't we put it in the record as to the surrounding area from the site itself? And we're showing a plan now. We're not introducing this unless we can pull it off. but there is not, we can't put the board in. Okay, let's mark reduced copy. Okay. I'll mark, this would be A7. And this is the area, I'll just make it part of the record. Again, I believe the board's probably familiar with the site. So go ahead, Tim, if you, we're showing the site here in yellow, and then if you can,
Yeah, I mean,
go ahead.
you've done a good job. There's not much more to say. Again, it's across the street from Wawa and also the Bryn Mawr Hospital. It's in an area that I would describe as a village-type setting, quasi-urban. There's a lot of commercial and a lot of multifamily. Glenbrook, it's a 5-point intersection, and this property is just off the corner, and if you follow Glenbrook down, there's a mixture of commercial and multifamily until you get to this approximate location where there's a surgery center. At that point, it becomes a little bit more residential setting. And obviously, as you stated, in between the 100 and the R5, it's more of a village-type setting.
And when you say the R100, that is right behind the site, is that
Yeah,
right?
the station is immediately adjacent. The parking lot for that station is contiguous to this property.
Again, it's basically across the street from the main Bryn Mawr Hospital building.
Yes.
Now, referring to what we've shown as A4, can you tell the board what the current uses of the site are? And I guess the first one is, why don't we just go in order, premises A, B, C, and F as in, matter of fact, D and E, that's a current restaurant-type use with apartments on the top, is that right?
Yeah, Building D has 3 apartments above and commercial below. It has Pasilio's Pizza, Certapro Painter, and a small tailor.
Right.
And then premises E is owned by the township, and there's 7 parking spaces.
Okay, it's just that actually there's no buildings, just 7 parking
It's
spaces.
just surface parking, 7 municipal parking spots.
Okay, and actually premises D, one of your entities or you have purchased premises D, correct?
We haven't closed
Oh, you
on
haven't
it, but
closed
it's
yet.
under contract.
All right. As to premises D, the intent, if it does close, is the restaurant on the bottom floor and to keep the apartment use on the upper level.
Correct.
Right. As to premises A, what currently exists there, and what is your intent as to what you would do?
As you described it, there's currently apartments up above, individual apartment units, 2 per floor, with what looks like was commercial at grade.
And that would be this one over here on the far right. Again, if we're looking at A3, it says premises A20, A22.
Correct. And premises A and B are almost identical in terms of the size and configuration.
Premises B being 816, 818 Glenbrook.
Correct.
All right, and you mentioned again, currently 4 apartments and 2 commercial spaces below.
Correct.
And what is your...
Excuse me, Doug, quick interruption. On A and B, are the apartments occupied?
No.
When were they last occupied?
Go ahead.
It's been many, many years, but we don't know the answer specifically when they were occupied. They still, if you were to walk through, they're still separately demised, and they still have the kitchens and the bathrooms, but they're in as Nick mentioned, they're in a state of disrepair. It's been many years.
Are the utilities hooked up?
I don't know the answer to that. I don't want to guess. I would say I don't know the answer.
Are they divided like apartments?
Yeah, they're separate apartments. I would speculate that the owners, Mainline Health, probably shut the utilities off to prevent any leaks or anything like that.
Is there...
Can I make an inquiry of the solicitor? What is the standard for the abandonment of that pre-existing use of residential?
I think that the standard would be that they, they do something to make the old use non-viable. And I think that we have, I believe, in the code, a 3-year requirement, do we not?
I think it's less than that.
Yeah.
Yeah, maybe less than that.
But that only creates a presumption of abandonment, which can be rebutted by physical evidence. Here, the applicant would argue that they've just been
Hold on,
closed.
let's let the applicant argue with whatever he wants to argue. But it sounds as if the presumption is it's been abandoned at this point.
That's what we're going to get into. I was going to ask them if they still have kitchens, if they still have bathrooms, if they still have
Okay,
bedrooms.
thank you.
As to premises A, B, and C, are they separately divided into individual apartment units?
Yes.
And each apartment unit, what does each apartment unit contain?
Depending on the size and configuration, generally speaking, some number of bathrooms and a kitchen.
All right, and so it does have a kitchen
Yes.
and does have has at least one kitchen?
Yes.
Are the appliances still in the kitchen? Is the
Yeah,
stove
they're in a
still
state of
kitchen?
disrepair, but yes.
Okay, and there is a bathroom, at least one bathroom in each apartment?
Yes.
And again, the appliances are still in?
Correct.
Now, we started to talk about, we mentioned A and C, and actually premises C, was there intent to convert that entirely to apartments, or was premises C, you were going to retain a small amount of retail?
The intent was to retain a small amount of retail. I don't want to jump ahead, but we feel that there's still some viability to the retail at grade at that location, close enough to the corner.
And I believe your plans indicate 800 square feet of retail? So it's not even, is it the entire first floor, or is it less than the entire first floor?
As we've proposed it, it's a portion of the first floor.
All right. And premises B, what is currently exists on premises B, and what is your intent?
Similar to A, there's 4 rental apartment units up above and 2 commercial units at grade.
All right. How long you've been added on this site?
2 years, approximately.
Okay, and when we say added, you've come up with a number of different plans?
Correct. When we first came in to make a presentation informally.
And when you say, who did you make a presentation? You were talking township staff?
Correct.
Okay.
Initially, there's been a lot of fits and starts to this project. Initially, we came in informally with what I would describe as a much more ambitious plan than this, that contemplated a complete teardown of this corner, assembled with premises D and E, and we found it to be over a period of many months just too complicated and probably overly ambitious. And then over that 2-year period, we continued to come in with different iterations of the drawing, each time incrementally scaling it back to the point where we're now making application, and the general theme is to reuse everything that's here and replicate the original intended uses for the most part. I don't know, do you want me to talk about the commercial?
No,
Okay.
Let's talk a little bit about parking. If these premises were converted to total commercial use, whether it be retail or offices, do you know how many parking spaces would be required?
Yes, because one of the prior iterations involved straight retail use on this premises. But are you asking me if you converted
Under code,
these
if you
under
convert-
code?
under code.
89 was the calculation. 89 parking spaces would be required if all of these 4 buildings became office. And if you were to do some portion of retail, it would go up from the 89.
Because you need
Employees.
On A5, I believe it shows what your code requirement would be for what you're proposing, which is 21 total apartments.
Correct.
And the 800 square feet of retail, and that would be 46
Correct.
parking spaces?
Yes.
And how many are you proposing?
30.
Have you done, we're going to have further testimony as to the parking, but what you've done other developments, correct?
Correct.
What is your feel as far as parking for this apartment use here?
Our feel is that...
From a marketing standpoint, let's just
From a
go first.
marketing standpoint, our feel is that in this particular location, with this particular type of product, that the proposed parking is sufficient.
Can I stop you there for a second?
Sure.
Give us a little bit of feel for the product in terms of, are these all generally 2 bedrooms or 1 bedrooms or a mix?
They're a mix, but the majority are 2-bedroom, just based on the configuration.
And the 2 bedrooms would have about how many square feet?
Approximately 900. They vary, but that would be an average, I guess.
For 2, would you venture a guess on who your target market is for the 2-bedroom at 900 square feet at this location, given its proximity to everything that's around?
The intent would be young professionals, proximity to transportation, proximity to amenities, restaurants, et cetera. That would be our target market. That would be the demographic. It wouldn't be college. It would just be market rate, better quality in terms of the finishes and the fixtures.
Why do you say it wouldn't be college?
Why what?
You say it wouldn't be college. What is
We
the
would
basis?
agree to put a condition on
Right.
that it would be no student homes, no student housing.
Since we're hazarding guesses, what's the likelihood of the 2-bedroom apartment dwellers having more than 1 car?
I guess it depends, but the thought here is that if you look at comparable product in this particular area is very similar to Wayne or downtown Bryn Mawr or Ardmore, those town settings, and even relevant, if you look down Glenbrook at our neighbors, very few, if any, have any on-site parking. I think maybe with a couple exceptions of the commercial uses further down, none of the residential multifamily has any on-site parking whatsoever. I think they rely on permit parking or street parking.
Currently, again,
I'm sorry, was there an answer in there to my question?
Of how many?
Which is how many people are likely to have 2 cars as opposed to 1?
Well, if it were typical, it would probably be most likely that they would have 2 cars. Our hope is that it's transportation-oriented, village-type concept, and that it might skew a little lower in this particular location.
and let's go back to the larger version of the plan, which I believe we've marked as A7. And how do the current residents along Glenbrook use their parking? Do they have parking on site first?
No.
And how do they park? Talking about Glenbrook, and first, how do they park? And then secondly, have you had discussions regarding how you would park any excess or overflow?
Yeah, to the best of our knowledge, these residents along Glenbrook, our neighboring properties, use, as I mentioned, permit parking. Or street-
Permit parking from whom?
From the township, from Radnor Township, or street parking.
Is there any really unmetered street parking that you would use for this site?
It appears that only between the hours of 6 p.m.
No, unmetered,
Oh,
unmetered.
unmetered? No.
I mean, your inhabitants, if they were going to have more than 1 car, or there would be overflow parking, where would they park, and what would be the intent on how they would park there?
Our intent would be any shortfall would be handled the way it's handled with our neighboring residents, which would be permit parking. That would be the intent.
All right, and have you done a study as to availability of spaces, in the evening or early morning during the weekdays?
Informally, in my 2 years' experience working with this property, I've had many occasions to be here all different times of the day, and I have yet in the municipal lot to see it more than a third full. And we, in anticipation of this hearing, we did take inventory of of both the street permit parking and the municipal lot permit parking in the evening.
Okay, and could you tell us what they were? First, the municipal lot, how many spaces are available in the municipal lot, referring to this lot here,
Right,
correct?
there's 53 in this lot.
And did you actually do a count on how many were taken at 7 or 8 o'clock at night?
Yeah, for the 2 nights this week, 2 evenings this week, we went out around 9 o'clock just to take inventory in anticipation of the hearing.
And how many spaces were taken?
7.
So that inventory was done this week?
Yes.
Do you happen to know when Villanova graduated? When the students went
They
home?
would have been, they would have graduated before this week.
Okay, thank you.
And is there any township limit on the number of parking permits that are issued? I understand the issue that there may be overcapacity in the municipal lot, but that's a snapshot, and maybe people were out and they came home at 10 o'clock or 11 o'clock and filled that lot up. So I think perhaps a more interesting question would be whether there is a limit on the number of permits that are issuable for parking in that lot.
That's correct, and that's what we sought to do this week. This was a bad week to get that data, because I agree, this is just anecdotal. What we want to know is simple numbers. We know how many there's 35 parking spots along the street, and there's 53 in this lot. How many permits were issued?
Mr. Richards, I agree with you, it may have been a bad time to get that information. Do you know when you applied to this board to be on the agenda for tonight's meeting?
Yeah,
It would have
About a month ago?
been a month ago.
Thank you.
Mr. Cornelia, what is the square footage devoted to residential now, assuming there's not abandonment,
Right.
versus the square footage that will be devoted to residential upon completion of the project?
Right. If you look on A4, the chart on A4, you have premises A. And premises A, you'll see that it has total gross area, which is the gross area that, I guess it's the 1, 2, 3, 4th item down. That is the gross square footage in each of the buildings. The line above that is the first floor, the
Yeah.
building area. And Tim, currently, the first floors of these buildings are commercial, is that correct?
correct,
And above the first floor is residential?
correct.
All right, so, for example, if you look at the chart, on premises A, the first floor is 2313, and the gross area, so the difference between 2313 and 6939 is the amount of the residential. The increase of residential would be 33%, basically 2,313 over 6,939. And the same with premises B, the same calculation, and that actually works out to 33% as well. As to premises C, it works out to 22%. It's a little bit less, but you can't use that full number because we are keeping 800 square feet of retail there, so that's why it works out to 22% on that site. Premises F, and that's the one that looks like a house, but we really don't have an indication. I think we're going to need a variance for that. And the amount there is, the amount of the gross square footage is 5,343 square feet.
Okay.
These are all separately deeded, too.
Yeah,
just
no,
to say that.
I understand that. So premises F is not able to avail itself of the special
That's correct.
exception.
I would agree with that.
Okay, so we have to,
Right. Now, also, I believe on A4, we have the required parking for the current uses on the site as well, and that would be adding up the bottom 2 columns. And saving the board, adding them up, it would be 63 parking spaces, is that right? 63. I mean, that would be the current code requirement for what is currently here if you assume that the apartment use is a legal non-conforming use on the upper floors. And as we mentioned on A5, we show that the required spaces for the proposed use is 46 parking spaces, right? Correct?
Correct.
You have to respond, you can't
Sorry,
not. Okay.
correct.
And so we're reducing the nonconformity regarding parking?
Correct.
All right.
Excuse me, Nick, does the couple calculations you just did, do they also include in the underlying assumptions, the building that you need the variance on?
Yes, it does. Yes.
So isn't the underlying rationale failing? Because you're suggesting that,
Well, the building that we need a variance for requires, if it was all commercial, we can take that out, would require 27 parking spaces.
thank you.
All right. The other buildings would require 14, 22, 26, 34, 36 parking spaces, just the A, B, and C. And what the proposal here is that you would have cross easements throughout the site for parking?
Correct.
That's all I would have for Tim. I have another witness I would like to call, unless the board has other questions for Tim, and certainly we'll entertain any questions during any course of the testimony if you have more.
Just so we're clear, we're only discussing A, B, C, and F tonight, right?
That is correct.
Okay.
D and E are not part. And on the township numbers, Bill, to answer your question, the police officer that's in charge of those numbers was on vacation this week. And it is true, we did apply a month ago, but that occurred that we should get those numbers this week, and he was out. The township's been helpful in trying to figure out those numbers, but he's the one that really has the numbers as to how many permits have been issued in that site. David?
Sir, if you raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
State your full name, please,
David Babbitt,
and spell that.
B-A-B-B-I-T-T.
And David, I'm going to hand up your CV, and if you could, while I'm handing it up, if you can tell the board what your profession is and what your qualifications are to testify here this evening.
I am a land use planner. I've been a planner since 1989, longer than I care to remember. I started out at the Montgomery County Planning Commission for about 8 years, been in private practice since then. I also teach classes in planning and zoning with the Pennsylvania Municipal Planning Education Institute, an institute designed to teach planning and zoning to zoning hearing board members, planning commission members, elected officials, and so forth.
Have you testified as an expert before boards and commissions in various townships regarding land use issues?
Yes, I have, including this one.
Okay, and have you also testified, including, I know the Board of Commissioners and Planning Commission you appeared before, correct?
Yes.
Okay.
Yes.
And have you also testified on zoning matters and the feasibility of zoning and use variances such as we're discussing here this evening?
Yes, zoning hearing boards. I've worked on validity challenges, special exception requests, and so forth.
I think he's good, Nick.
Okay.
Thank
You
you.
only had 7 pages, maybe not, but with 8, we're good.
David, have you reviewed this site, and what did you actually review when you went through this site analysis here?
Well, several things. First of all, I took a walk around the property earlier this week, took a look at aerial photographs, the photographs taken by the architect that you see before you, the plans that are before you. I've studied the Township zoning ordinance and comprehensive plan, and we've also discussed other issues, most notably parking.
Okay. First, let's talk about the use variance that we need for premises F here. You're familiar with the zoning requirements here in the C1 zoning district?
I am, yes.
And residential is not permitted in that district, is that correct?
That is correct, yes.
What is your opinion as to the commercial use for premises F?
It is my opinion that premises F cannot be used for commercial purposes. In my opinion, it was built as a house. It's designed as a house. The way it is set back from the street is the way a house would be set back. It cannot be used for commercial purposes.
Okay, is there other reasons regarding ingress and egress that makes it
Certainly.
not usable for commercial?
Several reasons. One is visibility. It's not as visible because it's, again, further set back from the street. Access to this site is difficult. It is available only through one driveway, and that is from Bryn Mawr Avenue. Parking is not visible from the street, which is what you'd prefer to have for a commercial property. And the number of parking spaces, I think we'll get into that, but is clearly lacking for any type of non-residential use at all.
And as you mentioned, there's only one way to get to the site, which is off of Bryn Mawr Avenue, and you wouldn't be able to access it through Glenbrook Avenue, even currently or as proposed.
I think once there was a driveway between premises C and premises B. I do not believe that driveway is still in use. It's awfully narrow. There's equipment, meters for the gas lines, air conditioning units that jut out from the walls. I don't think I would like to take my car down that driveway.
Are the buildings ADA, or can it be made ADA compliant from a commercial standpoint?
In my opinion, even if they could be made ADA compliant, which is doubtful, that would be prohibitively expensive. Each of the three premises on Glenbrook involves steps. Premises B and A involve steps down into the first floor retail. Premises C involves about 4 or 5 steps up into the ground floor. I believe 214 Bryn Mawr Avenue also involves steps up into the building. So none of the buildings at this point are ADA compliant for commercial purposes.
How about as to the parking? We've already mentioned that for the commercial code requirement for this would be 27 parking spaces.
For
premises F, excuse me now.
Specifically, yes. And there are only 7 right now.
All right, and we are proposing 6 apartments?
In premises F, yes.
Yes, and that would require, at least according to code, 12 parking spaces.
Yes, that's correct.
So again, it's much less of a nonconformity from commercial to residential.
That's correct. It would reduce the extent of the nonconformity significantly.
Do you have an opinion as to, there's been discussion of whether there's sufficient parking for the apartment use? Do you have an opinion on how those people would park who wanted a parking spot, that perhaps a parking spot would not be available?
Do you mean specifically for premises F or for all?
First let's talk about premises F and then for all of them.
Well, the answer is going to be largely the same for all of the properties involved. There's not enough parking on the site right now, and that's a simple fact, and there would be not enough parking regardless of any use proposed for the building. If people wanted to park there, some of them could park.
Excuse me, I want to interrupt right there. If residential development was proposed, and it was less dense than what is being proposed, couldn't there be enough parking?
Well, the answer is yes. If you wanted to make that one single-family detached dwelling, it would require 2 parking spaces.
What if there were 7 or 10 apartments?
Then, no, there would not be enough parking.
Not at all.
Not for premises F with 7 existing parking
So I'm
spaces.
talking about the project as a whole.
I'm sorry?
Talking about the project as a whole.
Well, there are 20 parking spaces. So if there are 10, then yes, it would.
Thank you.
Well, that would not include the commercial, however.
Thank you.
As to, did you also look at the comprehensive plan? Well, before we get there, would this be considered a transit-oriented site?
Yes, it would be the
We've
poster
had a lot-
child.
I know you've had a lot of experience with
The poster
transit-oriented
child for
Radnor Township.
transit-oriented development. You can't get closer to public transit than this property. The Norristown High-Speed Line, it's what I used to call it, the R100 line, is directly adjacent to the property, accessible both from Glenbrook Avenue as well as from a walkway along the side of the tracks from Bryn Mawr Avenue that literally goes right alongside the building, premises F. In addition, about a half-mile away is the Bryn Mawr train station on the R5 line, or whatever they call it now, the Thornburg line. And also, there are 2 bus lines on Lancaster Avenue, the routes 105 and 106. This is a very much transit-oriented development.
Have you reviewed the Township Comprehensive Plan, and is this development consistent with the Comprehensive Plan? If it is, why is it?
Yes, I believe it is. The emphasis on the comprehensive plan is preservation of neighborhoods, and it is my opinion that this sort of use is part of the Bryn Mawr neighborhood, as it were, some of which is in Lower Merion, some of which is in Radnor Township, but it's mixed use, small-scale residential uses mixed in with small-scale commercial uses and institutional and other uses as well.
All right. Does transit-oriented development generally require less use for residential use, or less parking spaces?
Less
for
parking,
residential
yes. Yes, it does.
And why is that?
Because, again, people are relying on transit much more so than they're relying on their own personal vehicles. If this development were located 3 miles away from any public transit, I think it would need more parking. But it doesn't, because I think there will be many people who will find it very appealing that they can just climb out of bed. 1 minute later, they're on a train down to Upper Darby and into Center City if they like.
Does ITE, which is the basic codes, and if you could explain what ULI and ITE are and what recommendation they have for apartment use for number of parking spaces?
Yes, ULI is the Urban Land Institute. It is a private, not-for-profit institute of land development. Its recommendations for parking for rental residential recommends a requirement of 1.5 parking spaces per unit, and that is not differentiated by dwelling size either, which suggests to me that smaller units, 1- and 2-bedroom units, will require slightly less than the 1.5 spaces per unit overall. 3- or 4-bedroom units would require slightly more. The ITE is the Institute of Transportation Engineers, a professional organization of transportation engineers, obviously. And in addition to their famous and riveting manual called Trip Generation, they've also done one called Parking Generation. And for parking generation, there are a couple of different land uses. They are low and mid-rise apartment, which are probably the closest to what we're talking about here. And the separation here is between suburban and urban uses, and I would suggest that this is somewhere in between. For suburban, they're recommending 1.23 parking spaces, and for urban, 1.20, both of which would be, again, well below what your code requires in this instance, and probably along the lines of what we would expect for the prospective residents of this site.
And so in this instance, I believe you are providing, not counting the commercial, 26 parking spaces for the units, for the apartments that we're proposing. Is that right?
Providing, yes.
Okay. Third, well, we count the retail, this 4, deducting the amount for the retail.
Right.
Which I don't, again, that is something that the consistency with the retail, and I believe that Tim has at least mentioned to me that, that's not a big issue here. He was thinking it's more of a,
I can't.
yeah, Tim, you're going to have to come up on this one.
Okay.
Would you have, if that retail was converted to apartment use, do you have any issue with that?
No.
Okay.
No.
And David, does the proximity to Bryn Mawr Hospital and have any impact, do you think, on the number of parking spaces that would be required for this?
Yes, I think it's part of a transit-oriented design, a traditional neighborhood design. It's walkable to a major employment center, almost literally across the street. Again, walkable to transit stops. The people who would be drawn to this type of setting are not the people who are going to have 3 or 4 cars per unit. They're the people who are going to use the transit. That's the type of people
Might
that
they have 2 cars per unit?
They might. Some of them, yes. Some of them, no. Some of them might be inhabited by only one person with one vehicle.
That would be the one bedrooms, right, presumably?
Not necessarily. There are 2 bedrooms that have one resident, and the second bedroom is used for guests, it's used for hobbies, for a home office, what have you.
So the one bedrooms could have 2 cars?
That's certainly true, but it's not likely that most of them will.
Now, another question. You mentioned something about not having students living there. Now, what type of students would be barred from it?
Yeah, the Radnor code, we would not have any student homes. So the Radnor code says if you're taking more than 6 credits, whether it's undergrad or graduate, they include graduate in there, that is considered a student home. So in that regards, that's what we mean by, we would not be able to have students.
Okay.
Does the effect of the municipal parking areas have any effect on your opinion as to whether this has sufficient parking?
Yes, it is my opinion that if there is perceived to be a deficiency, and the perception would be by the prospective residents of this development, they have the option of parking either on one of the 2 township lots. One is premises E at the corner, the other is to the, I guess, northwest, or street parking. They could get a parking permit, or they could do it on a case-by-case basis as necessary. There, in my opinion, there's plenty of parking available for the residential uses proposed on this site, and most of that parking is on the site. Some of the parking would be off-site and either on the street or on municipal lots.
Was that the Planning Commission's observation as well with respect to adequacy of parking?
The Planning Commission's recommendation, as I think you have before you, was that they loved the development. They had a concern about the number of parking spaces.
And that may not be dissimilar from where, I'm speaking only for myself, that may not be dissimilar from where I am.
Yeah,
The question becomes whether the lack of parking
Right.
outweighs the benefits of this proposal.
Yeah, we didn't go into a large presentation like we did this evening regarding, the municipal lots and everything of that nature. We probably had we probably did it in a couple of minutes. It was late in the evening. And, we didn't present all the evidence that we presented here this evening.
Are you aware that the Lower Marion has closed the lot on Lancaster Avenue nearest the hospital to hospital parking, and that hospital parking has to go into the either the garages or street parking? The lot, is right now is a couple big lot.
Yeah, I know. Here's Bryn Mawr.
Yeah, there's 3 lots for the hospital. This is one off of Bryn Mawr Avenue, backs up to Pennsylvania Avenue. The second one is kind of between County Line Road and Old Lancaster Road. And the third one, I think this corner right here, you just see the beginnings of the construction of that deck, which was not completed, I think, when the time of this aerial was taken a couple of years ago.
How about this slide here? What is this slide here?
I do not know offhand.
Okay.
There's obviously a great deal of additional parking for the hospital.
Staff and
staff
employees.
and visitors and what have you, but there are 3 large parking garages, structured parking garages associated with that hospial.
Because the lot I'm thinking about is right behind the Suburban Hardware on Lancaster Avenue. They have walled that off, closed that off to parking for the hospital. And so a lot of that parking has got to, because people don't want to pay for the garages, presumably that parking is going to move south.
It may well, but experience has shown that they're not filling up the lot on Glenbrook Avenue. When I was there earlier this week, the streets parking along Glenbrook Avenue was probably half filled or so. I was there midday, I think it was Tuesday. Again, that's available to people who work at the hospital. They can get a sticker just like anyone else can. Or they can pay on a daily basis if they like.
That's all I would have. I'm sorry.
Is there anyone here that would like to come up, talk to the board?
No, I don't think we really need to call Carl. I mean, let me just refer to Carl here and see if he has anything to add, so you're not. Just like to quickly recall Tim Rubin.
I just wanted to take one moment and just reiterate in a little more detail why we're here with this particular plan. I've been incredibly flexible in terms of coming into the township and very accommodating in terms of everybody's comments. And we've really, I guess what I'm trying to say is we've exhausted all other options for this property with the possible exception of tearing down and not rebuilding. And that is clearly an option. And that is clearly the only option for this particular site if we're not able to reuse, because I took to heart your questions about the number of units if there were less. I want to just reiterate, we're not densifying these three properties along Glenbrook. We're literally just replicating what's there with the exception of instead of 2 commercial units at grade, we have, through the help of Binswanger and over 2 years' experience, we have determined with a high degree of confidence that they can't be leased to commercial uses. So we're just proposing to take those 4 commercial units and make them residential because that is marketable.
And there's no enlargement of these
There's
buildings.
no enlargement, and there's no enlargement or densification of number of units. And if we were to de-densify, again, respond to your comment, it would be essentially taking, for example, in premises A, when you go up and there's two bedroom units on each floor, you could theoretically make 1 4-bedroom unit on each floor. It's not a marketable product because things are trending towards smaller units. But even, I would argue, even if you did that, you would still have 4 bedrooms and theoretically 4 parks. So you're not going to reduce the parking. Our thought was, again, to take what's here. We can't create structured parking. And the only alternative would be to tear down a structure and not rebuild it to create more parking. But I can tell you from a feasibility perspective, having become very comfortable with the pro forma, it would be incredibly difficult to make that work. Anyone, whether it's me or a future applicant, to come back and tear down a premises and create more parking is just...
Presumably, the pro forma is to some extent driven by your agreement of sale purchase price.
It is, correct.
And you haven't closed under the agreement of sale.
No, we haven't.
Thank you.
But it is, you do need a use variance to use the premises F for residential.
That's correct.
That's,
Yeah, on A, B, and C, we're using less than 50%.
You're okay on that, but
I
you're
would
not
say
okay
it's a special
on
exception
premises
on
F.
A, B, and C. For F, I would agree. We have not, it was a residential building, we think, at one time, but we have no indication that there's multiple apartment-type units in premises F.
Right. And there is flexibility. I would also just point out that when I met with staff, I mean, there were sessions where we, as the applicant, said, we're open to any ideas that anyone has. We've run straight retail, densified, multifamily, any combination of any type of property development you can imagine. And there's just, to my knowledge, no solution. So that's why we went back and we said, why don't we just clean up and restore what's there without adding a square foot? And that, I think that's all.
That's all I would have. I would request the exhibits to be made part of the record, please.
Yeah, I think you may have just answered my question, Nick, but I was trying to get my arms around what exactly you're asking for here.
Right.
So for A, B, and C, we're looking at a special exception.
Correct.
Right. So just on that issue, there's requirements for special exceptions. Has to be clear that the extension of the use is not materially detrimental to the character of the surrounding area. Area devoted to the nonconforming use can't be increased by more than 50%. Based on the testimony, it sounds like you've satisfied that requirement. There really is no extension, so we're not talking about any kind of height or side variances or anything like that. And you don't have any knowledge of any previous extensions to the non-conforming use for these buildings?
Now, Carl, do you know when the buildings were constructed? Ballpark?
My guess would be late 40s.
I guess we should swear him in if he's going to say. I'm sorry. Did we close or?
You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name for the record.
Yes, Carl Guttilla, Carl Guttilla, Guttilla.
What is your profession?
I'm an architect.
All right, you're a registered Pennsylvania architect?
Yes, I am.
Have you been able to make a determination of approximately the age of these buildings?
My best guess looking through would be late 40s, early 50s.
And you've also reviewed the current apartment uses in A, B, and C?
Yes, I have.
All right, and they have been fitted out as described during the testimony?
That's correct. They are intact apartments. They do contain, each unit has a kitchen and a bathroom at a minimum, and bedrooms demised also.
Do you know whether the utilities are connected?
The utilities are connected to premises F. I know that for a fact. I don't recall if these are connected or not. I don't think anything was on and operable when we were in there, so I really don't know.
So regarding premises F then, I mean, if we lump that in with the other buildings, you wouldn't meet the special exception requirements.
Correct.
But you're asking for a specific variance on the use of that property from commercial to residential.
That's correct.
And as I understand the testimony, that it in a nutshell, didn't make sense to have that space as a commercial space.
And also the testimony was that it really can't be used for commercial space.
Yeah.
Yeah, these are still separate lots, too.
Yes, they're all separate lots.
And while
yes.
you're going to do cross easements, that would probably have to be a condition of any
Right.
approval, they are still going to be maintained as separate lots.
Yes.
Okay.
Is there any other discussion?
I guess really the only point that I'm struggling with is the abandonment issue. And again, understanding it's a presumption. Some of the questions obviously have been going to that issue, and I'm not certain whether we've fully fleshed that out in terms of we're comfortable that it is in fact a non-conforming use as opposed to a mixed use that was abandoned, and now they're coming back for a new residential use in a commercial district. So I guess my thought is, does anyone else have thoughts around the issue of abandonment? Because there's nothing in the record which would indicate that Mainline Health has been looking for tenants for this residential.
I can make argument on that, but
Well, it wouldn't, the lack of a tenant up there wouldn't convert it to a conforming use. Would it? I mean, I don't think it would.
No, that's not my point. My point is that if Mainline Health has said, forget it, we're going to hold this for sale, it's no longer a mixed commercial and residential property, we're just going to hold the property in inventory and then find a purchaser for it who will do whatever the purchaser will do for it. The non-conforming use that's in A, B, and C, which is the residential portion, is abandoned for purposes of whether this is a special exception case or whether it's a use variance case. That's my point.
And I think based on the evidence that we have in front of us, it's been abandoned. And I don't think that either as to F or as to A, B, and C, there's been a showing sufficient for the grant of a variance.
Because the special exception standard is lower than the use variance standard.
can I address that, or should? I didn't make
There's
argument on
not
that.
a motion yet, so I think it would be unfair not to let you.
Thank you. I think the law on abandonment is pretty clear. There has to be, as you all said, an intent to abandon. And the fact that something hasn't been used for years is not an intent to abandon. Matter of fact, there's a case out of Radnor that some Cartha case that it was a carriage house that hadn't been used for years and years and years, and then they brought it back into line to be used as a residence. And the court said that the mere non-use is not enough to establish an intent to abandon. And much of the case law has revolved around the fact that if actual physical changes have not been made, that there is no intent to abandon. In this instance, there is no physical changes. Possibly the utilities were turned off, possibly, but that not in itself is not an intent to abandon. An intent to abandon these uses would have been pulling out the kitchens, pulling out the bathrooms, and in particular, in Radnor, it's always determined that a dwelling unit is defined by whether it has a kitchen and stove and things of that nature, which these all have. And, you know, for that reason, I would say there's never been an intent to abandon these uses. And if you look at them, they look like apartments. I mean, if you look at them just physically, they look like apartments from the outside.
John?
I'd like to have an executive session on this.
Guys, you okay with that? All right, we're going to take at least a 10-minute recess. So let's try to get back at 9:10. We're in recess.
fallow for another 10 years.
That is
Because the reality is,
run the string out of everything.
and if they shoot you down, it's going to at least a year. You can't come back in with another project in 12 months. Under Pennsylvania. Yeah, you can't like get denied and then come back in 3 months. I think there's a 12-month stay before you can come back. You might want to ask your attorney. I don't do a lot of land use anymore, but I remember it from prior.
You stayed at Holiday Inn.
Yeah, exactly. Good luck.
Thank you, John. With that, is there any discussion points or anyone would like to make a motion? Do you have any questions for the applicant or anything?
Yeah, go ahead. You first.
Well, I think I'm stuck on premises F here, and kind of what the hardship is there. You know, it has been used for commercial purposes. That's what I'm struggling with here. The rationale for getting a variance to make that residential. So
And that's exactly
kind of
where
what I
I'm
need
struggling as
help
well.
with.
Yeah, that's where I'm struggling too.
I think on premises A, B, and C, speaking for myself, I think I'm satisfied that we would qualify for a special exception for those 3 properties. But I'd like to hear any discussion on, you know, thoughts on premises F.
I'm in concurrence with you. I 100% in terms of A, B, and C. I think special exception threshold's been met, but I am still struggling with F.
I'm struggling not so much with F, but with the issue of the parking. I'm struggling with the struggle. Yes. One of the things that I would have liked to have seen, and we don't have, and I don't know whether the applicant would be amenable to forbearing for a month and getting the information, is the issue of the parking and the available number of permits that the township would issue. I understand schedules being what they were, the appropriate person in the township was not available to provide that information this week. They may have been available to provide that information last week, but we take what we have in front of us. I'm concerned about the parking, frankly, on the project. As the Planning Commission was, the Planning Commission, obviously Nick alluded to it, made no recommendation one way or the other on this, nor were they required to, nor are we obligated to follow any recommendation they might care to make to us. But the facts are they didn't recommend it one way or the other. They noted a concern about parking. It's the same concern that I have on the project. The difficulty is, I think, given the condition of the properties currently, I would like to see them improved. And this obviously is a project that would do that, and presumably would do it in a first-rate manner and improve that area of the township. But the question still remains in my mind whether those benefits are outweighed by the potential parking issues that are created by that many more residents coming into that section of the township. So that's what I'm struggling with at this point, and I'm also willing to and happy to hear any other observations from the colleagues here.
Yeah, I also have an issue with the parking as well as property F. It seems like there could be other uses made of A, B, and C that don't require either 4-bedroom units or the high density here. I guess there just must be some other way that it could be configured to allow that. And as for F, the fact that it's being used commercially, I don't see why it can't continue to be used commercially.
My concerns extend sort of at 3 levels. I heard our solicitor's judgment on the carrying of the burden, and I guess we can set aside the extent to which that's a decision for the solicitor, a decision for the board members.
That's a decision for the board members.
Okay, so I still have concerns about that. My concern regarding if we presume it's non-conforming use, continuing granting the special exception, has to do with the density of the development. I believe it's bringing too much density to this location, so I think there's a question whether it meets the requirement of it being no more detrimental to the neighborhood, which is in our code in connection with the extension of the non-conforming use. I don't think the burden's been met as far as the variance request. I'm reluctant to craft a motion because I know from my perspective it would be pretty black and white motion, which is, and if there's not a majority to head in that direction, I don't want to take us off route. But
Well, maybe we should take a stab at it then. I'd like to propose a motion that we approve the request for special exceptions for premises A, B, and C, deny the request for a use variance for premises F. I don't share the concerns on the parking. The existing nonconformities actually being decreased, and some of the other issues we talked about tonight, I'm satisfied on. So if I have a second on that motion.
Yes.
Yeah.
Then I will second that motion. With that, we'll take a vote. All in favor? Aye.
Aye.
Any against?
nay.
Motion is not carried.
In the absence of that, I would make a motion that relief as requested be denied.
I'll second that.
All in favor?
Aye.
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 Any against? Me? Motion is carried. With that, do you guys want to take a, keep them going? Okay. All right. With that, we're going to proceed to Appeal 2944. The applicant, Radnor Racket Club, property located at 175 King of Prussia Road in Zone PLO, seeks to modify conditions imposed by Appeal 1339 dated 1977, which granted relief to construct a tennis building. Applicant seeks to modify the relief to permit a portion of the tennis courts to be used as an indoor rock gym, rock climbing. In the alternative, the applicant contends that the relief is permitted by right or requests a variance from Section 28063 of the zoning code. Applicant seeks a special exception pursuant to 28089.8A, riparian buffer, to permit a sidewalk. Applicant further seeks any other zoning or alternative relief required pursuant to the plans presented with this application.
Okay,
Third
last time to
time.
see me tonight. Okay.
Hope you gave someone a discount.
And I know you have one left, and I may be able to get through this one relatively easy. This is the Radnor Racket Club. I think you're all familiar with Radnor Racket Club, where it's located. Biomed, or the old Wyeth site on one side, the old Chilton building, now owned by Brandywine on the other side, backs up to the Norristown high-speed line, the R100 that we mentioned earlier this evening. Across the street from the bus garage for the township, across the street from Penn Medicine at Radnor. Back in 1977, this is zone PLO. PLO, basically, as we all know, is basically laboratory office type uses. Back in 1977, the zoning board granted relief for the Goodmans to build a tennis club on this site. And that building there that, I think you're all familiar with is currently remains a tennis club. There are some other uses in there now as well that have been granted. There's an office use and there's a catering use. They've all received permission. The office use is permitted, obviously, under the PLO district. The restaurant use is granted as a kind of an accessory to the tennis club use. What we're requesting here this evening is, due to the decline in tennis, Mr. Goodman is asking that 2 of the tennis courts be converted to a rock climbing. It's still recreational type facility. The issue is that the old zoning decision referred to it as relief for a tennis club. It didn't say for recreational use, it said a tennis club. And as I said, what we're proposing here this evening is to convert 2 of those courts to a rock climbing type facility.
This is all interior.
All interior, no additions. They are constructing additional parking. They're putting a walkway in that goes through the riparian buffer, even though the building itself and the walkways are in the riparian buffer, but we are adding a walkway that would go into the riparian buffer, so we need a relief from that. So the 2 things we need relief from are that we need a modification of the condition because it was a tennis club, and again, even though it's recreation, the order itself says as a tennis club. And the second relief we need is a minor de minimis relief on the riparian buffer, since a walkway is going through the riparian buffer, even though, a current walkway already exists over top the riparian buffer, actually.
So, you are putting on the record that you only want to convert 2 tennis courts?
That's
that would
correct.
be it? That would be the extent of where the rock climbing could be?
That is correct.
Do you have any idea of what the increased traffic would be? How many more people could be at this facility because of that?
Yeah, we can present testimony on that. Remember, it's a very heavy traffic site already. It would be very minimal if there is any increase, certainly minimal both in the increase and also minimal as to any potential increased traffic as a whole on this site or in this area. We do have some testimony we can present regarding that as to, I think it's relatively similar, because normally with 2 tennis courts, if you're using it you normally would have 2 teams of 4 or 2 teams of 2, then 1 waiting, so it would be 6, so you'd have basically 12 people, I guess, on 2 tennis courts. And it's kind of similar to what the rock climbing would be. The rock climbing facility, you can go in and actually get lessons to learn how to rock climb. You can have a rock climbing party, just like you would have a tennis party. So the uses are pretty similar as to both traffic and intensity and everything of that nature, and employees. And
How about time of day, Nick?
It is going to be 12 to, I think the tennis club use now is probably 6 a.m. to whenever you close at night, and the rock climbing, I believe, is around noon to, again, whenever you would close, the general closing hours in the evening. And then on weekends, again, you would have, probably similar hours during the weekends that you currently have for the tennis club use. I can call Lloyd up. Again, I think we're familiar with the facts, and we'll try to get through it as quickly as we can.
Lloyd, oh, sorry. You do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, nothing but the truth.
Yes.
And state your full name, please.
Lloyd, L-L-O-Y-D, Goodman.
Lloyd, just going through the exhibits, A1, we've marked as the application. You reviewed the application, you signed it, correct?
Yes.
You're the owner of the property, right?
Yes.
And Radnor Racket Club is the owner?
Yes.
And I've marked as A2, that's the deed to Radnor Racket Club. This
Yes.
deed, I think, is from 99 because of Delaware County, DCID. The Development Authority was involved in it, but if you look at the deed, it refers to, 1977, actually.
Correct.
Okay. And that was you and your dad, and
another partner at the time who was no longer involved.
all right. And back in 1977, A3, your dad, Stanley Goodman, came in and asked for relief for a tennis club, correct?
Yes.
And the order itself does refer to appropriate order for the construction of indoor tennis building.
Yes.
All right. The proposal here this evening is to convert 2 of those tennis courts into a rock climbing facility.
Yes.
Both of them are recreational type uses?
Yes.
All right. We've marked as A4, the plot plan, and really, there's no additions being made to the building, correct?
Correct.
We're just adding a parking lot, which is shown on this A4, for which a grading permit has already been applied for.
Right.
And as we also mentioned, there's a small encroachment into the riparian buffer here. This, if you look at A4, there's a stream located here, correct?
Yes.
And then the riparian buffer, which is, I believe, 35 feet.
Yes.
Is this dotted line.
Right.
Part of the building is already existing in the riparian buffer. The walkway from the parking lot crosses the riparian buffer, and what you're proposing is a small walkway, this portion here, that would be in the riparian buffer. This is actually further from the stream, the existing walkway, but that would also encroach in, this portion here would encroach in the riparian buffer, right?
Right. I think it's about a 4-foot wide sidewalk, and the engineer has a more exact linear footage. Here it says 17 to 20. Oh, no, that's the actual encroachment. I think it's about a 20-foot walkway, or a little more, that's in the riparian.
Now, I've marked as A5, and this is the interior of the building, and you're maintaining, currently there are 6 tennis courts, right?
Yes.
And you're maintaining 4 of the tennis courts,
Correct.
and Gravity Vault is taking over 2 of the tennis courts.
Right.
They would enter they would actually have an entrance to the parking lot, but that would be, what would that entrance be used for?
Well, mostly, I think that's really going to be a fire exit,
Okay.
as it actually is now.
Right.
And we're proposing to put the walkway to get to the tennis entrance, because it's, that way you don't need an addition, have a nice entrance. And also, we can share the lounge, so you'd come in through there and then walk down some stairs to get you to court level and to the rock climbing level. And that also leads you to the locker rooms, which they also will share with the tennis players.
Is that walkway part of this application?
Yes, it is. The walkway is part as the riparian buffer relief.
Okay, you said it goes alongside the building?
Yes.
Yeah, on the previous
This
plan.
little piece here? Okay.
Is the parking, the rock climbing, the new parking, the rock climbing tenant exclusive, or is it for all users of the building?
We're going to say it's exclusive for them. I mean, it's at that end of the building where, but most people would not choose to park there for the other uses.
Just in a minute, because I'm not quite sure, just explain all that parking. Where do your current customers park, and who else uses those spaces currently?
So referring to A4.
Yes.
Okay, and when you enter the property from here, from King of Prussia Road, you start getting spaces here. Here's the, should I use that now? Here's the walkway to the tennis entrance.
Right.
So tennis players predominantly park here. If you drive further down, this represents another walkway and a bridge across the stream. Stream's not shown right there, but to the banquet catering facility.
Right.
So they tend to park in this area.
Okay.
Then the office, then you can drive this way and drive across the stream. Here's a service entrance and dumpster to the banquet facility. but you can drive up here, and here's the parking for the offices.
Do your current tennis customers generally find parking when they show up?
Yes, there's a vast amount of parking for all the uses at all times. We only anticipate the occasional once-a-year time or something when all uses are at their maximum. Then there'd be, but otherwise there is such a vast amount of parking for everybody. So they're so complementary because the restaurant, the banquet facility really is mostly only Saturday nights. There's no office use at all Saturday nights. We used to have tennis parties, but that's part of the decline. Now we rarely have people Saturday nights, so it just really complement each other.
So the parking, though, is mainly the extent and the number of parking spaces is more for the catering facility when they're using the facility. Need that number of spaces.
Well, I mean, by zoning, they need 84, and we have 141, so.
You don't have any issue with people parking somewhere else except for on-site?
Correct.
Even during the heaviest time?
Not that I'm aware of.
Okay. Just A6, this is the tennis court, and I believe the two courts that are being taken over by the rock climbing, is that right?
Yes, that's like the view from the tennis lounge or the stairs there, looking towards King of Prussia Road.
Okay. Do you own any other tennis clubs?
Yes, Bryn Mawr Racket Club in Lower Merion.
All right, and you mentioned decline of tennis. Can you elaborate on that? And is that the reason why your business requires you to convert part of this to the rock climbing?
Yes. Well, since we opened the tennis in '78, we opened Bryn Mawr Racket in '76. It was, tremendous business. And then about 6-7 years ago, both places were slumping. I don't run Bryn Mawr Racket Club. I'm a partner, and I built it with my father. But I have a tennis partner there who's a tennis pro, actually, and he runs his business a fair amount differently than we do at Radnor, and both have slumped, pretty similarly. We've had conversations with other indoor tennis club owners who actually came to us with, what's going on? Is there anything we can do? And it's really just seems like a national, maybe even international. People just aren't playing tennis as much as they used to.
Is there a reason for that, you think?
Well, we've, put our heads together. There's probably quite a few. Some of us disagree on what the reasons. I think some of them are that the proliferation of very nice fitness clubs that are around. When we opened in the 70s, they didn't have that. So some people choose to do that early in the morning rather than play tennis. It's, one person. You don't have to line up people to play. You don't have to learn how to play tennis. You just go in and, work on a machine or something. And then maybe also the proliferation of more team sports. I know back in the day, there's some little leagues, but there weren't all these other sports and leagues, soccer and basketball. Now, as you know, with our kids, they did a lot in Radnor Township. So, we still get some kids playing, but they're not following through when they grow up and become adults.
Okay, just a couple other pictures showing the site. A7, if you could just describe what that is, and maybe you can show, I have A7 and A8. I don't know which one's best to show where this walkway is going. A8 obviously shows the crossing, the stream, and the sidewalks or the walkways already in the riparian buffer, and actually it shows part of the building in the riparian buffer as well. And if you just can show the board on, we have it on A4, but if you can show from a picture on where that walkway would be going.
Okay, this is the walkway to the tennis entrance. As you enter from the parking lot, you'll be walking along here, crossing the stream. So the riparian buffer starts back in here and continues up on the other side of the stream, approximately there. So instead of going up to the tennis entrance, most people would enter this way. The other lot is up over here, which is really more for employees of the gravity vault and maybe overflow for those odd times when there isn't enough parking back in here. So the new sidewalk that goes to riparian buffer kind of comes off, right here off the tennis walkway, goes this way, and then up out of the riparian buffer, up along the building and around.
Just showing some pictures of the surrounding area. A9 is just the driveway coming into your site, correct?
Yes.
And 810, actually, you're next to the, as we mentioned, the high-speed line.
Right, that's an access,
Station.
yeah, that's their access driveway. They have an easement. Radnor actually owns half, and Brandywine, not Brandywine, sorry, Biomed owns the other half, but there's an old easement there for SEPTA.
And that just shows, again, like, the 89 is just showing the surrounding areas, showing the current Biomed site, showing the bus garage across the way, showing Penn Medicine at Radnor, and then showing, what I still refer to as the Chilton Building,
Right.
the Brandywine Building.
Right, the Radnor Financial Center is their more
Is that what
exact
it's
name.
called now?
Yeah.
I have Lucas also from Gravity Vault who would testify as to their proposed use. I also have Patrick Spellman from Yerkes, which I can bring in to testify regarding Parian. I don't think it's really necessary, but you're welcome to hear from Patrick. And I don't know if you want to hear from Lucas at all or not. Okay.
You have 6 tennis courts currently, right?
Yes.
Okay, so it's,
I do have two quick questions. My understanding is the new use going to be leased, or how's that work?
Yes.
Okay. And has the planning commission seen this proposal?
Yeah, they won't need to get this because it's not a land development,
Okay.
because we're not adding anything, so.
But, well, yeah, okay. They don't need to weigh in on the parking, the new parking in the
No,
front?
that's a grading permit. And they're going to have to do stormwater management and everything else according to township code.
Okay. Is there anyone from the audience that would like to address the board on the matter? Great. With that, would anyone like to discuss or make a motion?
I'd like to make a motion. I'd like to make a motion to move to modify the limitation to the variance issued for this property granted in 1977 so as to permit 2 of the 6 courts in the existing tennis building to be converted to a rock climbing use, and to grant a special exception to permit the extension of the existing walkway within the riparian buffer setback to the extent shown on Exhibit A4.
A second?
Okay. All in favor?
Aye.
Aye.
Aye. Aye. Against? Abstentions? It's carried. Thank you.
Thanks.
Okay, the final, you want to take? All right, we're going to take a 5-minute break. We'll be back at 9:40.
admit the
9:40, so we'll, wait a minute, we're missing someone.
Okay, we're going to be out of here by...
So we'll get back into session. Our final matter for tonight is Appeal 2946. The applicant, Michael Giordano, property located, Giordino, thank you, located at 447 Inverray Lane in Zone R1DM, seeks a traffic home occupation under Section 280-115-1, home occupations of the zoning code. Good evening.
Good evening. How are you?
Great. How are you?
Great.
You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your name for the record.
Michael David Giardino. And if the board will bear with me, I seem to have a lot of neighbors back here. I don't feel comfortable with my back to them. So I think I'll stand over here.
You're going to need a microphone. Great.
I am an architect, and I reside at 447 Inverary.
TV, will they be able to see him?
I'll double check, but I know that there's a camera there that
Okay,
catches
good. Okay,
the
as long as you
staff
can
here,
be
so let me
seen.
just double check.
Because we have all the viewers watching, so.
Okay. I am an architect, and I reside at 447 Inverary, along with my wife, Laura, who is also an architect, and we are partners in an architectural firm called L&M Design. I wonder where that came from. Our application here is, for this evening, is I think, a technical one, as opposed to a really material one, but given the number of neighbors that are here, there may be some level of misunderstanding or disagreement on that. What I would like to do is first clarify what the ground rules are, because maybe the board members know, but most people, and certainly Laura and I, among them, being planners, we didn't even know this. There are two classifications of home occupancies in Radnor. Okay, the first classification is called a non-traffic home occupation. It is a by right category permitted to everyone in actually Pennsylvania to operate a business concern from their own personal residence, with the stipulation that not more than 35% or 400 square feet of the residence be dedicated to business use. The business activity must be conducted solely within the dwelling. Business-related deliveries must be via passenger vehicle, light commercial vehicle, parcel or mail service vehicles typically employed in residential deliveries. In addition to that, under the non-traffic by right, off-street parking of a single commercial vehicle is permitted. Commercial signs are prohibited, and there may be no use of hazardous material, equipment, etc. in the non-traffic home occupation. So basically, when Laura and I go down into our basement studio and do our architectural things using our computers, etc., we're acting under that particular provision. The reason I'm here tonight is we have one employee, and the one employee apparently triggers a second classification. That's called a very, I think, honorously worded traffic home occupation. It is a conditional permitted use, which is why we're before the board. When approved by the zoning board, a traffic home occupation is permitted only in a single-family detached house. There may be only one such occupation permitted per dwelling. There may be no more than one non-resident employee permitted on the premises at any one time. And the quote-unquote public hours of operation, whatever that means, are limited to 8:30 a.m. to 8 p.m. weekdays and 9 to 8 p.m. Saturdays. Not more than one client or customer may be served per hour. Off-street parking to accommodate at least two vehicles, unless found unnecessary by the zoning board, shall not be located in the front yard of the building. And parking for the traffic home occupation is to be in addition to the 2 spaces required for the residential use. The zoning board may require screening of the additional parking, and there may be only one traffic home occupation permitted within any 500-foot radius of another home traffic occupation. In addition to that, any approval of a home traffic occupation expires upon the sale of any given property. So those are the 2 types of home occupations that are permitted in Radnor. As to the background in our particular case, we've lived at 447 since July of 2000, and over those past 15 years, we've raised a combined family group, and between us, we have 7 children. From 2000 to 2011, living with us at Inverary, the number of children varied from 5 down to 0, and now back again to 1. This last fall, one of our children matriculated at Temple, and she lost her rental, and she moved back in with us. So we've had an extra person hanging around for a couple of months. She's just graduated, and hopefully we'll be finding another place to live shortly. However, we're not counting on that necessarily. Back in 2011, the last of our full-time live-in children started at Drexel, and we only see him when he's hungry. So we basically were living in a 4-bedroom house, 2 people, and there was a lot of air. Now about L&M Design. L&M Design was founded back in 2002, and for its first couple of months, we ran our business out of the basement of our home while we had an office being prepared for us downtown in Wayne. And once we moved to Wayne, we slowly expanded from 3 people to 16, and our business is designing multifamily, mixed-use, retail, and large-scale master plan communities. Our client base consists principally of large-scale public and privately held developers. They are located for the most part in New Jersey, New York, Massachusetts, Maryland, and a couple now in Pennsylvania. The majority of our work is from out-of-state clients. Following the downturn, which we all are too familiar with, of 2007 and 8, we found that our clients quickly retreated from the development of new projects, and between 2008 and 2010, our L&M staff was reduced from 16 back down to a core group of 3, 2 of which are L and M. And during this period, we progressively reduced the size of our Wayne offices. Finally, in April of 2012, with the last of the student types out of the house, we decided to move back into our basement because the house is basically sitting there empty all day, and we're paying somebody rent to have an office. We continue to operate with our core group of 3, Laura, myself, and 1 employee. And since April of 2012, we've been in our studio basement, unknowingly a traffic home occupation. Laura and I are the principal residents of 447, and we are the principal architects at L&M Design. As I've stated, we do conduct our business out of our basement studio. The work consists of programming, designing, and providing construction observation services for our clients, and it's principally done on computers, except for the field work, which of course is done wherever they're building their project. The interface between L&M and the clients is principally via telephone and visits to client office locations. Client visits to our home studio have been very rare. I think we've had a total of 8 such visits over the past 3 years. As I said, most of our work is done electronically. Delivery of supplies, such as paper products and art supplies, does occur periodically, about every 6 weeks or so. Occasionally, at the end of a project's development, we receive a delivery of construction documents that have been prepared by consulting engineers at their offices, but they're big rolls of drawings, and we do get them. All the deliveries are via common carrier, such as UPS, Federal Express, or delivery services in passenger vehicles. All outgoing packages are either sent via Federal Express, we use the Lancaster Federal Express office location, or via U.S. mail, and we do have a post office box in Wayne for that purpose. Our employee, I'll call her TB because I don't think her name is important, arrives in the morning at about 10 a.m. and TB works until 5:30 on Mondays and 2 p.m. on Tuesdays through Friday. We have no operations on the weekends other than chili parties. TB is a graphic artist. She does her work on computers and also some hand-drawn graphic work. Her artwork is typically scanned through one of our machines and then either professionally printed at an off-site location, like the Federal Express office, or sent directly to the clients as a PDF file via computer. The work undertaken by TB requires very little to no additional traffic at Inverary in terms of delivery supplies and that kind of thing. Employment of TB does require one payroll drop-off every 2 weeks, and all of her work is conducted in our studio basement. Fortunately, we have experienced recently a pickup in business activity among our client group, and in order to address that, we have some additional demands. We've begun to work with some consulting architects and draftsmen. This work has been undertaken in a fashion that is done on a project-by-project basis, and it is largely performed off-site in the facilities of those particular consultants. There was a period in August 2014 to January of 2015 when we did have one consultant, I'll call that person PA, work in our studio, and he worked on Tuesdays through Fridays from 3 p.m. until 8 p.m. after TB was gone. Since the first week of February, he has conducted his operations from his own home. So he hasn't been visiting us recently. A second consultant, I'll call JC, has conducted all of his work from his own facilities, and he will come and meet with us in our studio to review his work. He's been to see us 4 times since January. He comes in an late afternoon, early evening time frame, well before 8 p.m., I would say. In addition to that, since this April, we have had the pleasure of hosting a Drexel University student as an intern, and this young man's BM, I'll call him, is an active student studying engineering. He's on a work-study co-op program and is requested to spend some time to learn more about the profession. He actually wants to be a structural engineer, but he figures he can learn something from an architect, which is quite surprising. He is not our employee, but rather a student guest. We have attempted to schedule BM's hours so as not to overlap with those of our principal employee person, TB. And BM has other obligations which interfere with his presence on a regular basis. So he has classes that he has to attend. He's a member of a crew team. He has a lot of practices he has to go to. And since he wants to be a structural engineer, we've arranged for him to spend a couple of days a week with one of our consulting structural engineers. So we only see him 3 days in the afternoon. His internship, parenthetically, will end this fall. Now to our request for the granting of a conditional use. It's our understanding that the basic operations of L&M Design, undertaken by Laura and myself, are conducted by right, and we don't need to be before this board. We're here for the non-traffic home occupation. Those base activities which trigger the need for this conditional use request are the presence of an employee, and I'm presuming it's her automobile that's the issue, not the person who is in my basement during weekday hours. In addition, sporadic visits from consulting architects and draftsmen may be an issue that triggers it, and sporadic visits, even though they are very sporadic, from our clients may trigger it. We request that the zoning board grant our request for a non-traffic home occupation, and I would like to go through the stipulations that
I'm
we
sorry,
must
excuse
show.
me, it's a traffic home occupation.
I'm sorry, a traffic home occupation. I'd like to go through the stipulations that the code mandates that we demonstrate. The first one is that the size, scope, extent, and character of a conditional use variance be consistent with the comprehensive plan of the township. We have the following points to make on that regard. The operations of L&M Design are in the basement studio of our home and are practically invisible to the Inverary community at large. The addition of one car arriving at 10 a.m. during the weekdays adds only a de minimis burden to inventory traffic loads. In cases where a second visitor arrives after the primary employee has left the premises, the additional car and traffic is also of little consequence to the inventory traffic load. The addition of one employee to the permitted non-traffic use adds no further burden to the inventory community insofar as deliveries are concerned, since the deliveries are generated by the needs of Laura and Michael. The operation of L&M Design Studio is very quiet and completely out of view to anyone in the community, other than getting in and out of a car. The operation of the L&M Design Studio is not of a retail commercial character and has involved only a very small interface with clients. The second requirement is that the proposed conditional use constitutes an appropriate use consistent with the character and type of development in the area and surrounding location, and will not substantially injure or detract from the use of the surrounding property or the character of the neighborhood in light of the zoning classification of the area affected. The effect on other properties in the area, the number, extent, and scope of nonconforming uses in the area, and the presence or absence of the neighborhood, in the neighborhood of conditions or uses which are the same or similar in character to the condition or use for which the applicant seeks approval. So here I would restate the same list that I just enumerated for item A, but I'll save you the pain. And also state that Inverary is a planned community with a contract landscape service maintaining the grounds. This service is present at the community Monday through Friday, beginning in late March through the fall season, and during winter months after snowstorms. During the summer months, landscape work crews park several vehicles, trucks, vans, trailers, etc., along the Inverary roadway, with operations beginning somewhere around 8 a.m. and concluding in the late afternoon. Activities include general landscaping, maintenance, mowing, weed whacking, fertilizing, leaf collection, and in the winter, driveway snow removal. In addition, they undertake private commissions for individual homeowners. The crew of 6 or more individuals can be seen on a more or less daily basis walking and riding mowers about the Inverary community. The intensity of this operation, noise, traffic generation, delivery of gardening materials, etc., stands in great contrast to the character of the use conducted by L&M Design, which is quiet, non-obtrusive, and generates negligible traffic. Many Inverary neighbors park their cars and SUVs in their driveways, as you might expect. A casual look indicates homes with from 1 to 4 cars parked in their driveways. Laura and I happen to park one personal vehicle in our driveway, and our now returned daughter parks a vehicle in our driveway in the evenings when she's home. She generally arrives home between 7 and 8 p.m. and leaves for work between 5:30 and 7 a.m. on most days. She parks the car in the driveway on weekends when she's home. There have been occasions when she returns home during the afternoon, and of course, then we have that car. All these things are consistent with the area use patterns that we observe in our community. In fact, they're less intensive than when we had 5 kids at home. Over the past 15 years, we have consistently observed a good deal of on-street parking by visitors to neighboring homes, and we've observed regular postings of temporary no parking signs along one side of the Inverary Drive to accommodate large group meetings, particularly at the front entrance at Inverary. The parking of an additional vehicle in our driveway at 447 in connection with our studio operation is completely in character with the practices of the neighborhood.
Can I ask a question?
Yes.
Just because on that point I was wondering, it's relevant there. You referenced the parking in the driveway. I couldn't tell from the pictures, I don't know. Does your employee park on the street or park in the driveway? Or
Before we were aware of this situation, she was parking in front of our house on the street. As soon as we became aware of this, we told her to park in our driveway behind the front line of our building, which is what she's been doing.
Thank you.
We have observed consistent, if not daily, service to Inverie residents, other than our own residents, by UPS, Federal Express, et cetera, delivery vehicles. We note that the school bus passes by Inverie at least twice a day. Maybe more, because I think there's 2 different bus services. The level of additional traffic resulting from our one employee is practically nil. The next proof is the proposed conditional use be suitable with respect to traffic highways in the area and provide for adequate access and off-street parking arrangements in order to protect major streets and highways from undue congestion and hazards. And of course, here again, I would restate what I've already said in A and B above, and note that the number of cars being parked at 447 is no greater now than it was from 2007 through 2011, when we had at least 3 cars, and sometimes 4, at our house with family members. The next proof is item D here on your list. Major street and highway frontage will be developed so as to limit the total number of access points and encourage the frontage of buildings on parallel marginal roads and other roads perpendicular to the major street or highway. Well, this is, in our opinion, not relevant to our discussion tonight, so I'll just keep going. The next one.
I think E you can cover, and you can skip F and G because they're not, I interrupted you right before E, but not only I think is D not relevant, but F and G are just, they anticipate construction and you're not constructing your industrial uses.
Exactly.
So hit on that E and then you can jump down to H and I.
Okay, great. E is the proposed change is reasonable in terms of the logical, efficient, and economical extension of the public services and facilities such as public water, sewer, police, fire protection, public schools.
Excuse me, a little bit slower.
Sorry? Where'd you lose me? I'll start again. The proposed change is reasonable in terms of the logical, efficient, and economical extension of the public services and facilities such as public water, sewers, police, fire protection, and public schools, and assures adequate arrangement of sanitation in specific instances. And our comment on that one is that the requested conditional use places no additional burden on the above, with the single exception of a somewhat increased volume of recycled goods due to our use of paper in the architectural practice. Item F we're skipping. Item G we're skipping. Item H is regarding conditions which the board may set. And, we're prepared to stipulate that we'll abide by the conditional use conditions controlling the days and hours of operation, numbers of employees present, number of clients present at any one time, which will never get anywhere near what's permitted, and the off-street parking requirement. Given that we have such a low density use, we don't think there's really any other things we should be asked to do, but we'd be willing to listen. Of course, we have no need of a commercial vehicle either. I didn't even mention that one, but we don't need a commercial vehicle. Item I, the proposed change, I have to show that that protects and promotes the safety, health, morals, and welfare of the township. And I would offer to you that as architects who design multifamily housing for the general public, our professional activities actively protect and promote safety, health, welfare, morals, and general for the population. L&M Design has been a good contributor and member of the Radnor Township community for over 13 years as a company. And I rest.
Mr. Giardino, I have a couple.
Hold on one second.
Oh, I'm sorry, Brad.
Before we go anywhere, let's just mark the exhibits because I know I'll forget. Just take the application, A1. I guess we did the site plan, A2.
Hold on. The deed. The deed will be A2.
A2, okay.
Yeah, but the site plan is A3.
A3. And just you do the pictures as a group.
And the pictures is a group for A4.
And the application including the write-up. That is
Yes,
correct.
that's it.
Great. Okay, sorry. Just want to get that in. I always forget, so.
Sorry. Just a couple questions. First, do you know whether there are any other traffic home occupations within 500 feet of your residence?
Yes, based on the township's review, there are none.
Okay. Secondly, and this is, I get more for my information than anything else, is there a homeowners association in this development?
Yes, there is.
And I'm assuming that homeowners association has bylaws or some other controlling document that...
Yes, they do.
And is the use that you're proposing or the use that you are conducting permitted or not, well, is it
not
permitted
prohibited.
under those bylaws?
It is not prohibited.
Okay.
It's not spoken to.
Okay.
Mr. Chairman, excuse me, as a point of order, during the previous testimony, we heard a lot about a conditional use. This is a special exception, not a conditional use.
Oh, I'm
Just for
sorry.
clarification.
Yep. Thank you. Are there any other questions? Otherwise, we'll hear from the people that have shown up. Okay. With that, if someone would like to come up, we'll take you in order. Whoever wants to go first.
Mr. Chairman, the email.
We'll do. Let's hear the testimony first and put that in last.
Fine.
Mr. Chairman, Anthony Verway. I'm here on behalf of the Invery Homeowners Association. I'd actually like to ask a few cross-examination questions before we present any testimony, if I may.
Sure, that's proper.
Mr. Giordano.
Giardino.
Giardino, I'm sorry. You said you work in the area of land development and planning, is that correct?
We're both licensed land planners in New Jersey, and we do land planning in a wide variety of jurisdictions, yes.
So you're familiar with zoning ordinances?
In general?
Did you check your zoning ordinance to see if your use was permitted back in 2012 when you started?
No, I didn't.
Okay. So you know that for the last 3 years you've been conducting this in violation of the zoning ordinance?
I know it now, yeah.
Okay. Now, where in your house is L&M's office space located?
In a third of our basement area. It's approximately, we measured it today, about 385 square feet of space. We have some computer workstations and some files.
Is it an open floor plan?
We have a mechanical room and stair that kind of sits in the middle of the footprint of our basement, and this is tucked around one side of that.
Do you have any walled offices within this space?
We have an office partition that separates this space from the balance of the basement, which has a pool table and TV and stuff.
Okay. Now, what kind of facilities do you have as far as, do you have a bathroom facility in your basement?
Yes.
Do you have a kitchen or kitchenette?
There's a sink.
Okay. And your employees use these facilities?
Not typical. Well, they use the bathroom.
Okay. They don't use the bathroom upstairs in your residence?
No, there's no need.
Now, as far as furnishings, how many desks do you have in your office space?
We have 4 computer desk stations.
Do you have any drafting tables?
They're at the same station.
And approximately what size are those drafting tables and desks?
2 of them are 4 foot wide, and they might be 36 inches deep, and they have a parallel edge on them, and a side table that might be 16 to 18 inches wide with files under it.
Can I pardon? We need to get to issues that are relevant to the hearing. I mean, the specifics of the
submit
desk.
that these are important because there's going to be an issue of size. Now, his testimony is he's only using 380 square feet.
Which is what he testified
What he
under
testified
oath.
to, so I wanted
what's
to
the
see
issue?
how he's using it, I'm challenging the veracity of that statement based upon how much he has in that. Well, now
So you're
he
saying
knows
he's
what I'm
lying. That's what you're trying to prove.
Well, I'm trying to see if he's being completely accurate in his representation regarding how much space he's using in the basement.
Well, we measured wall to wall.
Again, we don't want to waste anyone's time here, so we want to make sure that we're getting to the issue here.
Tied into the zoning regulations and their requirements.
That's
which
all
this
we
is
need
not
to hear.
part of.
The
Everything
400
else is
square feet is
irrelevant.
actually quite important because that's a requirement. that he used not more than 400 square feet of floor space.
And he testified that he's using 380.
Right, and
So,
I was attempting to challenge that, but I appreciate your patience.
again, it's 10-10, so we're,
Right.
we want to just get to the relevant points.
Well, if I may have just a little latitude,
You can have a little, but I will
appreciate
intervene
that.
if we need to.
Thank you. Now, does L&M have a website for its office?
We have a website for L&M Design, yes.
Right, and isn't it true that on your website you indicate that your address is at 447 Invery, Suite 100?
Well, that's what we call it, yes.
Okay, Suite 100 your basement?
Yes.
Okay, is there a separate entrance to Suite 100?
No.
Other than your front door?
No.
And where are deliveries made?
They come to the front door.
Okay. How many employees do you have total? Not just on-site, but altogether?
We have one employee.
Okay. And you have consultants?
Yes.
And they're occasionally invitees into your premises?
Yes.
Okay. And you have, including your intern, 4 invitees that could come to your office and work?
We have one employee who works part-time, and we have, at this point, 3 additional, one being the intern.
Right. So, but they're invitees, they could come to your office and do work at different times, correct?
When we invite them to come, yeah.
Right, okay. Do you have any marketing or public relations employees?
My wife handles the marketing for the firm.
Okay. Now, would you describe your neighborhood as quiet?
I'd say it varies from being very quiet to being extremely active.
Okay, and you testified earlier there's no home occupations in your development?
There are no home occupations registered with Radnor Township within 500 feet of our house. That's what I know.
No traffic.
Well, the other kind you don't know about at all because how would you know?
Okay. Are you aware of any traffic home occupations anywhere in your development?
No, as I've said, Radnor checked. There are none within 500 feet.
Just clarifying, you're would be the sole traffic home occupation. Are you aware of any non-conforming uses within your neighborhood, such as another business, a commercial use within that neighborhood?
No.
Okay. And you testified you only used 380 square feet of floor space in your basement?
Again, Counselor, that's not a requirement for traffic home office.
Actually, the 400 square feet is...
That's for a non-traffic occupation.
Actually, subsection B states that you have to meet the elements of subsection A in order to have the...
Subsection 280-115-1A.
115B states that...
Again, we have testimony that's he's under oath. If for
Okay.
some reason he's above that and then someone finds out, they're more than happy to call the township and they'll come down and inspect it.
I have no further questions.
Thank you.
May I call a witness?
Sure.
Thank you. It'll take a few minutes. I have 4, and then I'm sure some neighbors will want to testify on their own.
Sure.
If that's permissible. Call Joe Reiser. I'll give you that.
Sir, if
Let's have him sworn in.
I'll swear you in. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I didn't quite get that, but I assume you asked for my name. It's Joseph Reiser, R-E-I-S-E-R, resident 500 Heather Circle in Inverary.
I'm sorry, 500.
500 Heather, like the name, Circle in Inverary.
I don't think he actually sworn. He didn't swear.
Yeah.
He didn't swear.
You have to swear.
Do the oath.
I'm sorry, that's why I didn't hear. I swear that I'm
Thank you.
who I just said I am and live where I
Has to
do.
be under oath.
Thank you.
Sir, are you a member of the Inverary Homeowners Association?
Yes, I am, and I'm the current president.
Thank you.
For the last 3 years and going on 4, I think.
Okay. Now, as president of the HOA, have you communicated with neighbors regarding the proposed special exception to allow the traffic home occupation?
Yes, I did that in 2 ways. The first The first reason is, the reason this came to our attention, we have an annual inspection every year by an independent outside contractor, and I think they noticed a sign on the front door of the 447 that indicated this business, and that's where the first contact came to us. We subsequently then, of course, I inquired whether there was a license at Radnor. I called Radnor.
I can't hear.
You turned your mic off by accident.
Battery died.
Sorry, it wasn't me. So then, once we found that out, we contacted Radnor to inquire about whether there was an approval for this home office, and we were informed there was not. As a result, Radnor then contacted the homeowner, and then this resulted in this appeal. Second point is, in the meantime, Radnor then communicated with our entire community. Actually, I thought it would only be with the adjoining homeowners, notifying them of this appeal. So in that regard, that was communicated to the entire association of 62 homes. And beyond that, I communicated to clarify what I think was just done previously in the last few minutes, what the difference is between a traffic and a non-traffic-based home business. A lot of questions about that, and I referenced your information on your website as to that difference. So that was the extent of the communication. Do you want me to continue?
See if you use that one.
Okay.
Battery's dying on that.
Okay.
Could you just please, and please be as brief as you can, give a very brief overview of the neighborhood community in Inverie?
Right. So just very briefly, I've been a resident for 10 years. I've got to know the community pretty well by now. It's a very unique community of about 62 homes and 5 additional homes which are larger, which are kind of tangential. It's a 30-year-old community, and I should say most of the lots are about a quarter acre, so we're very closely aligned. I can walk out of my home and I can readily communicate with my neighbors in general. Many homeowners there are long-term residents. I'm 10 years, and I'm probably one of the shorter residents, if you will, in time. But the other point I should make is that most of our residents have invested heavily, and I mean heavily, substantially, in their homes. And I think that's a common denominator, and that's one of the reasons why I think our community is so desirable. The other point is that I think most homeowners, including me, chose the community for, I think, for the environment, I think the unique residence in terms of its location, and which I think it is very much today.
And could you just, in a bullet point fashion, you don't need to elucidate too much on it, just give the 2 or 3 reasons why there's opposition to this application.
Okay. I was certainly the recipient for this, almost exclusively. I must tell you, in the time period that I've been at Inverie, I've never seen such a consistently polarizing issue.
I'm sorry, excuse me for just a second. The witness is testifying to things that other people have told him. Are we comfortable with that? When it appears there may be others who are able to speak on their own behalf with us this evening that can do the same thing?
The rules of evidence are relaxed in the zoning hearing, and he can testify if it gets wildly inappropriate. We could object, but again, we only give the the testimony the weight that it's that it bears.
But I guess my issue, John, is given the hour and given the fact that there might be others who are going to testify very much in the same way that we're going to hear from Mr. Reiser, the issue is how cumulative do we need this testimony to be?
There is no question that the testimony as to what other people said, as opposed to having that person come up, it's himself or herself, the latter is the more desirable thing.
I will only summarize top line. I won't be too redundant. I understand your point. However, I can tell you that I've received spontaneous either emails or direct calls of about 30 homeowners, all and uniformly in opposition to this proposal. in addition, and just to give you a reflection, we have about 20 homeowners present tonight who've taken the time till 10:10 or later as it is to come here and voice their concerns. So this has been a very strong response by the community, much stronger than I expected. I think very briefly, there are 4 reasons, and I'll go very briefly through them. You may hear them again, but this is what came to me. Number 1, traffic. And the traffic was already discussed here. Any more traffic in our community is a detriment in my view. And I should tell you, Inver is a relatively closed community in a sense, one way in, one way out. So we feel all traffic very readily. Number 2, related to traffic safety. Inver used to be considered a 55 and over kind of community. When I moved there, today over 10% of our homes have children, and very young children. We see now children riding their bikes when I didn't see any for the first 3 years when I lived there. Thirdly, I think the perceived impact by homeowners on home value is very real. The thought is taking a community from that it is now into a commercially oriented environment, and again, this could be with more and more of these home offices, is a very deep concern by homeowners. And I think the last point is that the character of the community could change dramatically, and I think this is a very strong concern by most homeowners, given the fact it's a very serene, very residential, very stable, and very safe environment. So I think the overarching issue here is the precedent of approval of traffic-based home offices that would be allowed on the community in the long run. So I think that captures probably at least the main points that came to me via these homeowners that have communicated directly or indirectly.
Thank you. Rather than bring up additional witnesses and ask them questions, it'd probably be more productive for the board to just have them come up individually, make their statements, and allow you to ask the questions you feel appropriate, so you can get through that process a little more quickly if that's acceptable to you. There are a number of neighbors here.
No.
Sure.
Sure.
Mr. Reiser, obviously you've been made aware that some of the neighbors in our community are perhaps not happy about the announcement that they got in the mail that says traffic home occupation. Clearly,
right.
That announcement did not explain at all what we were seeking to accomplish. We were told specifically not to put anything else in that envelope. I kind of had hoped that I would be able to explain that. But I'd ask you this. This application was made several weeks ago, and obviously you've been talking to people over several weeks. Did you ask us what we were up to so you could share that with the neighbors?
I didn't. I think it's just dead again. I did. I'll go this one. No, I did not. I simply reacted to the announcement that was sent to us by Radnor in terms of the appeal, and then proceeded to follow that appeal process. So we did, also receive under FOI your application, so we were very aware of what you were asking for. Any other questions?
Great. We'll have the first homeowner who would like to speak. Just make sure, again, state your name under oath, and for us, where you live in relation to the applicant.
Sir, do you promise to tell the truth, the whole truth, nothing but the truth?
I do.
And state your full name spelled.
Kevin Duffy, Kevin Duffy, 468 Inverary. Just very briefly, my wife and I moved here 5 years ago from North Jersey. We picked Inverary. We invested very heavily in our home, and we really see this changing the nature of what we invested in. The community gets devalued. This is starting down a slippery slope. It's a precedent that could replicate itself. Be hard to not grant for additional variances. And we just think that would be really unfair to change the deal that we thought we bought into which was a residential community, not a business community. And so it just wouldn't be fair to the community. That's all I have to say.
Can I ask one question? I guess I'm trying to get a better idea of what's really going on in the neighborhood. I understand your feelings and everyone's here, but we've heard testimony that the effect on traffic will be minimal, nothing more than that has been going on in the neighborhood that other people might have, the number of cars and so forth. Is there any specific testimony that you've observed, trucks coming in every day making deliveries or something to that effect? What's the actual facts of what's going on up there?
Well, I think what's going on, and Joe alluded to, that we're talking about moving down a slope of residential businesses, and one, I'm sure, as you read in the application, it's very minimalized, but who's monitoring? Sadly, we're now coming to this 3 years after the fact, and so nobody can know what else in terms of observation. And my concern is that 500 feet away, the next application comes up, and then 500 feet away, the next one comes up. And now we're, Inverary, those of us have, again, made really substantial investments in our homes. We've remodeled stem to stern, landscaping, completely changed our house, and now we find we live in a business district. And, and that just doesn't seem fair to the community who have made those investments. And that's, I think, from my perspective, the biggest concern is the individual specific impact of this one as described, the nature. From my perspective, it's about the next 5 and the next person who can minimize their application to squeeze through.
Let me just briefly say, us as a zoning board, we're here to enforce the code. And as I think you've heard today very eloquently put it, there's provision that says you're allowed to do it if it's non-traffic. So we all have that issue in the township. It can happen to anyone. And obviously there's some extra requirements for a traffic home occupation. So we're kind of confronted with that. If that's something that is, you feel that is of concern, obviously we're not the board, we're not the panel to be talking to. That's the commissioners to talk about the code. We can talk about this a little bit further, but the bar for a special exception is low. So I just want to say we're here to take a look at a code provision and say, did he meet the burden for a special exception, and did he meet the requirements of the provision itself? Other than that, that's about it. We can't change the code. We can't say, can't do it anymore. And this provision is not unlike every other provision that's in the code, which is sometimes the township can enforce it. Most of the times they rely on the citizens to say something's wrong.
Well, I appreciate that.
And that's our duty.
And I appreciate that. We were here all night and observed discomfort with issues on other applications, and so it was not exactly rigorous. It was well-intended and thought out, but not exactly, black or white.
Absolutely not.
Okay.
So the key for us when you're coming up is just telling us why you oppose this. Is it a traffic thing? I think you did a great job at eloquently 4 points, because that will help us, because there is still a burden for a special exception. So, and it's adverse to I got to use the right word, the public interest. So help us understand in what way you think having this will be adverse to the public.
And also, the one case that was denied, that person needed a use variance. That is the hardest thing to get. This is authorized by special exception, which means that the drafters of the code thought that it could be, the use could be conducted in this area subject to compliance with all these conditions. If there was no home occupation provision in there, that would be a use variance, and we would be constrained. And that's a lot of what we do. We're constrained to follow the code and not give things that the code doesn't allow, but we're constrained to follow the code.
And there's dimensions of judgment in all of these things. That's all I was saying. Does we're starting down a slope, a precedent that lets the nature of the community change from what it was to, every 500 feet, where, in, a dentist office who stipulates one, who knows where it stops. And that's, and again, like you're telling me that you don't make the code, so tough. Right. I understand. And we think this affects us substantially and economically.
Thank you.
Thank you.
Sir, if you'll raise your right hand, you promise to tell the truth, the whole truth, nothing but the truth.
I'm sorry, I have a hearing impairment.
Do you
My
promise
name,
to tell the truth, the whole truth, and nothing but the truth?
yes, I do.
And state your full name and spell your last name.
My name is David Faulkner, spelled F-A-W-K-N-E-R. I live at 450 Inverary, across the street from the applicant and one house down. You're right, it's late, and we're all going to be covering the same material. My wife and I purchased this house about 11 years ago. It's our retirement home. We have spent a tremendous amount of money in rehabbing this house. We picked it because of the uniqueness of the community, the character of the community. We weren't really looking for a business park, and that's one of the concerns that I personally have, and my wife as well. We keep talking about the slippery slope. I think we all know what we're talking about. If this is granted, this variance, then what's to stop another one? And that's our major concern. And again, that's really all I have to say at the moment. If any questions?
Mr. Faulkner, you heard the applicant's testimony regarding his intense, the nature of the use and the implications to the property. Did you find that generally accurate?
From what I understand, yes.
Okay, in terms of
I don't know the
cars on
square
the streets,
footage. I've
cars
never
not
been
on
in
the
his
street.
home, so I really can't give you any witness or any accuracy as far as how much space. Again, I've never been in the house.
But I'm also talking specifically about what the use looks like from outside the building in terms of parking or traffic or deliveries.
Well, living so close, initially I noticed there was traffic. There were more cars parked there than normal. And I began to ask, what's happening? This is some time ago.
Okay. Thank you.
You're welcome.
Raise your right hand. You promise to tell the truth, the whole truth, nothing but the truth.
I do. I'm Loretta Allen at 445 Inverary Road.
Your first name again?
Loretta, L-O-R-E-T-T-A, Allen at 445 Inverary.
Allen is spelled?
A-L-L-E-N. We moved into Inverary in June of 2012. Happy to move into a community that had 3 school buses every day going through. What I have to show you here, I'm not trying to be the bad neighbor. This happened after one of the school buses went through. You can see there are 2 FedEx trucks there at the same time. Our streets are narrow, so for a bus to get through, 2 trucks one on the street, one in the driveway, is kind of consistent. I'm worried about the traffic. I'm worried about the kids. It's a problem.
Can you talk into the microphone?
I'm sorry. I feel it is a problem. Any questions?
I'm having a hard time seeing what's going on in that picture. So you're saying there's a FedEx truck in the street?
Would you like to see it up closer?
Yeah, that would be helpful.
Yeah. I took that picture after the school bus went by, so I could...
Excuse me, Mr. Chairman, I would recommend that we put that back on the table and we can zoom in so that
Okay.
everybody can see it and it can be on all the monitors.
Right in the center. Sorry. Now it's not going to work. There. This was taken, I believe, in March. It's
Speak into the microphone.
I'm sorry. I believe this was taken in March after the school bus went by, and I was in my driveway.
Is it,
Yeah.
hold on. Is the street of a width where with that truck there, the school bus could get by?
It can get by. How safely? You know,
Are there any generic parking regulations on the street? You know, some residential streets in the township, it's either no parking on one side or no parking
No.
certain times, or, okay, thank you.
May I ask a question?
This is not the good time.
Sorry. Can I ask you a question of,
Well,
is she a witness?
we'll wait till the witness is done.
Just wait till her
I'm
testimony
finished.
is told.
What is my,
Do you happen to know what the FedEx truck was delivering? Sorry.
no.
Do you happen to know? Because, I mean, could be from Amazon, it could be,
No, I do not.
okay.
I was going to ask, do you know where the FedEx truck was delivering?
To you.
How do you know that?
Well, when they walked up the grass.
They walked up the
Well,
ground?
the driveway.
Do you get FedEx deliveries at your home?
Yes, I do.
Do you think our neighbors get FedEx deliveries at their home?
As often as your house.
Into the microphone.
I'm sorry. I don't think we get as FedEx or UPS deliveries as often as the Giardinos do.
It's for good shoppers.
I know. Better than me.
Mr. Giardino, you need to get in the mic, please.
Okay.
So, Ms. Allen, if I could just summarize your testimony, you're in opposition because of your concern about the traffic safety.
Traffic safety and the school bus safety.
Okay.
Okay.
Thank you.
Promise to tell the truth, the whole truth, nothing but the truth.
I swear.
State your full name, please spell.
Linda Hearn, Hearne. I live at 401 Inverary, which sits at the base of Inverary. So every car that comes into Inverary passes by my house. Every car that goes out of Inverary passes by my house. So I'm definitely impacted by traffic. I have 2 children, 2 dogs. Both my parents live at the house. So we have a lot of people at our house, but it's residential. We live as a residential, in a residential district. We live as a family. The only point I want to make here is that I would say that what's being requested here for business does increase the traffic, because you can't compare the activity that's going on in the neighborhood for residential purposes with a commercial purpose. So I would say this request is increasing traffic into the neighborhood because it's bringing in commercial business into the neighborhood that would not otherwise be there. You can't compare what they're doing with the bus coming in and out because it's a residential area. We have houses and you're going to have that traffic, and we accept that. But when you buy the house, you don't think you're going to have the kind of traffic where somebody's running a business. And I share the same kind of concern that if you approve one, that there may be more. And the other thing, I'll just make a point, if they have one employee now, who's going to police whether their business grows, real estate's coming back, and they get a few more employees and they put them down, where, who's going to police that and control it? Thank you.
Thank you very much.
Sir, promise to tell the truth, the whole truth, nothing but the truth.
Yes, I do.
And state your full name, please.
Stephen Brown, live at 428 Inverary Road. My wife and my 2 daughters have lived in Inverary for about 10 years now, and we moved here because we like the feel of the community. It's a quiet community, one way in, one way out. We walk the community often. My concern, or our concern, in addition to what some of the other residents have talked about, the slippery slope in terms of maybe being additional businesses there, but also like the last person said is, this is a business that has declined from what it was before substantially. And as the real estate market improves, who's to say it's not going to grow substantially? We've got 1 employee now. We've got independent contractors, consultants who are coming and going from time to time. Who's to say that in 2 years' time we won't have 5 or 6 independent contractors in addition to the 1 employee who are coming and going? And as the business grows, those people are probably going to need to have more face-to-face time with the owners of the operation. And this could become a very busy office. It could become something close to what it was before. And that's my big concern, is that this is a business that I'm sure the owners hope is in temporary decline and could grow substantially in the next few years. It's also, you know, like somebody said before about policing, how are we to know how many people are working there? You know, it came to light that there's this type of business there, not because the owners came and asked for the exception that they're asking for now, but they're asking for it because it was discovered. And as the solicitor sort of indicated, you know, you could interpret it that in the line of business they're in, they should have known that there was some sort of exemption that they should have at least looked into to see if they should have needed. So that also lends to the idea of who's going to be policing what's going on, and can we really count on them to police themselves?
A quick question, Mr. Brown. Were you previously, before the notice came out about this hearing or the notice from your homeowners association, were you aware that this was going on in the property?
No, I was not.
Okay, thank you.
Swear to tell the truth, the whole truth, nothing but the truth.
I do.
State your name and spell.
My name is Christopher Priate. I'm at 427 Inverary. I'm probably 4 or 5 houses away, I believe, and around the corner.
Spell your name, please.
So I'm sorry, Preate. I live, you know, probably 4 or 5 houses down around the corner. I'm one of the homeowners that have 2 small children. I have a 5 and a 6-year-old. We moved to the community in 2009 after we had our first child. We had our second here at Inverary, and my children are now of the age where they're riding their bikes around, you know, the neighborhood. So I have a concern over the traffic because my kids are out there playing, you know, in the cul-de-sacs on the street, riding their bikes around. So any increased traffic is a big concern for me, having my children out there. Now, obviously, my wife and I are with them most of the time when they're doing that, but, you know, any traffic creates a problem, so I have a concern with that. 2 of the requirements, I think the first 2 requirements for this special exception kind of lead to similar items, which is, you know, is this consistent with what the Radnor Township Comprehensive Plan contemplated? And it also says, is this use consistent with, you know, what the general nature of the community is where this business is going to be operated? And although, you know, he says that the intensity of the use is, you know, fairly invisible, that may well be true. I don't know. I'm at work most of the day, so I don't have the opportunity to sit out in front of his house and watch the activity that comes in and out. But this community, it's completely inconsistent to have a trafficked use here. There isn't any other home offices here. There haven't been in the 30 years of the community, as far as I know. So, you know, the intensity of it is not necessarily relevant. The standard is it consistent with the community itself? This is a one-way in, one-way out community. And I would, you know, suggest to the board that it is inconsistent, and, you know, the intensity of his use is not really, you know, dispositive of whether, you know, he's met that requirement. And I noticed in his application that he, you know, had several pictures of, you know, of cars along the streets. You know, he took the opportunity to take pictures on days where one of our neighbors at the bottom of the street happened to be having a party and, you know, had, you know, a large party, and so he had a valet, you know, service. The police had come and blocked off one side of the street to ensure the safety of the rest of the homeowners. So the pictures that are in his application are somewhat misleading in terms of the activity that is there on a regular basis. I mean, I can say for me, I probably get 1 FedEx, you know, package delivered, you know, maybe once a month, maybe every 2 months. You know, I'm not a heavy user of that. It's only for, as you say, an Amazon package or a, you know, some sort of internet, you know, purchase. So, you know, and to, you know, say that, well, our landscaping crew is there, you know, performing work. Well, you know, we have a homeowners association. We have large common areas that need to be maintained. That's not that commercial operator operating in our community for his own benefit. He's operating there for our benefit. So the fact that his workers and his trucks and, you know, and his equipment are there on a regular basis is not relevant to this application. It shouldn't be considered by the board as, you know, that is much more intensive a use than his use. because it's not there for their commercial purpose. It's there for our purposes, to keep our community at the level and the high standards that we've kept them. And I agree with Joe's 4 bullet points. I think they clear some, there is a slippery slope here, because the next guy who comes in, he's going to say, well, you granted it for him, why can't you grant it for me? Which then is only going to increase the traffic and increase the concerns for me as to my children. And it just, it's something that it's not right for this community. It probably, if you looked around, I didn't have the time to go and look to see, what a home offices with traffic uses have been granted by the township, but I would suspect that most of them that have been applied for were probably in residential areas that were closer to the commercial corridors, where they were likely to have it. I would be surprised if they're in these private, communities, where they just don't, we're so far off the beaten path. There's nothing remotely close to this use, in our general vicinity.
Thank you. Any questions?
Could I ask a question? I'm not a witness. I'm not
No.
resident of Inverary. I'm not part of the contingent, but
Sorry, you can't. You can testify, but you can't ask questions.
I can come up here and what's
It-
the
it's-
testify? I guess the question is not testifying.
Correct. Yeah. Are you finished? Or
Yeah,
are you,
unless the board has any
Any questions? No? Okay. Next.
Sir, you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And state your full name and spell it.
Jack Kelly, Kelly. I'm at 406 Inverary. I've actually been there 5 weeks, so I'm one of the newest members. And in fact, I've seen my neighbors, most of them for the first time. Thank you. Well, we're from Wayne. We lived on Pembroke Avenue for 22 years and sold our house last June and looked really for 10 months in this neighborhood, in the whole area to buy a place. And I would have done it sooner, but my wife was looking for a certain place, and this is really a fine community. We looked at a lot of condos and townhouses and communities, and this is the place we settled on, so it's very special. I don't know the applicant, and I kind of feel badly for him. He's trying to run a business there, but I would agree with most of what was said here tonight from our viewpoint. I realize it goes beyond the scope of what you're going to do. I do wonder about how, if his business grows, how it's going to be policed. The only other thing I would add is, when I saw the notice in my mailbox and I Googled the name, the address in Inverary comes up all the time. So once you start doing that, it looks like, if you were just looking at it, you wouldn't know it was a residential neighborhood. They do have a post office box. I wish they'd use the post office box on their website. Then you wouldn't know where it was. He could still run his business, but it's just very obvious when you put that name in that, the website says 447 Inverary. And you see that all over. That's probably, something new I'd add that bothers me. That's all I have to say. Thank you.
Thank you very much.
Sir, you swear to tell the truth, the whole truth, nothing but the truth?
I do.
State your full name and spell it.
Martin Josephs, Josephs. I live at 455 Inverary, and I've lived in the community for approximately 8 years, and would reiterate the reasons why I moved to the community. My major concern is the increase in traffic as well, but it more relates to a safety issue for me. It stands to reason as their economy improves and their business grows, as I'm sure it has and will continue to do. There will be more traffic. Both my wife and I work during the day. We are not home. We do not have any children at home. It's just the two of us. And I am very concerned about more traffic coming through and people noticing patterns of what people in the community do, who's around, we are not around. And I'm concerned about strangers noticing that we're not there in the house during the day. And while we have an alarm system, that doesn't preclude someone from attempting a break-in, and that is the safety concern that I have with the increase of potential traffic as the business grows.
Great, thank you.
Thank you.
Sir, you swear to tell the truth, the whole truth, nothing but the truth?
I do.
And state your name.
Joe Dewberry, live
Spell.
at 600 Inverary, 600 Lindsay Circle, excuse me.
And spell your last name.
Dubbarry. I just have a question. Is an intern an employee? How many interns can you have? Can you have 6 interns and not have them count as employees? He has employees, 1 employee, but he has an intern working for him. That's 2. He has other people coming in and out, consultants. Is an intern an employee?
Unfortunately, I mean, I was to say, the code, first and foremost, the code doesn't define an employee. So, I would take it under general business principles. You pay W-2, you pay taxes for it, they're an employee.
Can he have, 6 interns come and work for him?
We have a code that says you're not allowed to have more than 1 employee. So we have to, if he's adhering to that, then that's what we have in front of us.
Is that intern an employee then?
The question is, do they pay the person? I mean, that would be one of the factors that you might go into
Is that the answer from the
It's my
council?
opinion.
From the council?
Should I respond?
Can I answer? Can I ask him?
He's our counsel.
Mr. Chairman, the witness makes a valid point, and I think he's making his point in the context of a question. I don't think it's incumbent upon us to try to answer that question. I think you're making a point.
I think you understand my point.
We do understand your point. If you have
absolutely.
other points to make, you should, but just repeating the question to us over and over again is not benefiting your point.
It's a question of head count. That's your issue.
Yes.
That's
correct.
right.
Thank you.
Is there anyone else?
State your name again, please.
Sure. Chris Priet. One other point is, you said that the purpose of this board was just to interpret, whether he's met the burden, it's someone up to someone else to enforce the ordinances and the rules, and that he's abiding by them. The problem with that is that Radnor Township doesn't do that. You're not sending people over to monitor his business, and what you're doing is you're creating what is a friendly, very congenial and collegial, neighborhood, and you're now turning us all into the police to ensure that, they're operating their business within the confines of what you guys, agree that they've met the burden, or if you choose to impose additional standards on them. And what you've done is you've shifted the burden from the township now to us to police whether he's complying, whether the traffic is more, whether the employees are more, whether the clients that are coming are in excess of those of the hours. And that's not what we bought into this community for. So this takes it back to that that kind of point that I made earlier, that this is just completely inconsistent with the nature of the development where he's trying to operate this business. And I would suggest that he hasn't met the first 2 burdens of the test. Thanks.
Thank you. Is there anyone else that'd like to speak? I hate to do this, but I'm going to call for a recess. I think we need to, I specifically need to talk to the solicitor about an issue. We will try to be brief, 5 minutes, because just like you, we want to get out of here too. So give us 5 minutes, and we'll be back. So we'll reconvene at 11 o'clock.
Yeah, that's right. Letterman's done, so.
All right, with this, it's 11 o'clock, we're back in session. Does anyone else want to make any further comments before we have a discussion? Sure, come on up.
My name is Joseph Reiser, and I'm still under oath, I believe. I neglected to make one, I think, a very pertinent point, and that is the fact that our community has no sidewalks. So everyone who walks the children, and the 80% of the homeowners, I dare say it might be 90%, sometimes I think it's 100%, have dogs. So everyone who walks, our community walks on the streets because there are no sidewalks. This is probably one of the biggest safety elements that I neglected to emphasize, and I just wanted to make sure that you're aware of that. That was my only other comment.
Thank you very much.
Thank you.
Just, I'd like to have our council, you'd like to come up? Yeah. Okay.
My name is Janet White. Yes, I will tell the truth. My name is Janet White. We live at 420 Inverary, and it's WHITE. I don't think this should be a personality. I don't think it should be a neighbor issue against a neighbor. So I would like to have that not be the issue as far as I'm concerned. I feel that we moved here because it was residential. The communities and all the business today are changing. They're all becoming, they don't go to an office, they go into houses. And so many people don't even have to go, and they're in the homes. And because we moved here as a downsizing couple, I feel that it opens us up for lots of people who do great things for themselves, moving in and doing and having businesses in their home. And I would like to discourage that from happening and encourage them to go where it is just an office with lots of secretaries and all that support, but not in Inverary. Thanks.
Thank you.
Absolutely.
Certainly. Certainly, yes, I do. Laura Staines Giardino, Staines Giardino. And I want to thank the residents, our neighbors, for joining us tonight, and thank you all for hearing our side of the argument, so to speak. But I wanted to clarify a few things, and I think there's a gross misunderstanding, first of all, of what we're asking for, and secondly, of the impact of what we're doing. And unfortunately, I think the terminology in the zoning ordinance that states a traffic occupation merely expands on, the unknown, or does not correctly transmit what is actually transpiring. When we're requesting a traffic occupation as a conditional use, or a special exception that is, it's to permit one additional individual to join us in our office. And admittedly, we were not aware that that required a special exception, but we do know that in the state of Pennsylvania, in the Township of Radnor, and in Inverary, home occupations are permitted. And in fact, before many of the residents that are here in attendance bought into Inverary, there were people who had home occupations. In fact, one of our neighbors did. So it was not uncommon for commercial vehicles to come in and deliver products to this person's home. So, of course, we didn't feel that we were unduly altering the character of the neighborhood when we elected to start a professional business in our office, in our basement. And admittedly, we had a very thriving and very flourishing business in downtown Wayne, doing business all across the East Coast. The economy, unfortunately, did a number, not only on us, but a number of people. We're very fortunate that our business is picking up. We've had the opportunity, and unbeknownst to our neighbors, we have conducted our business in our home, has not had any detrimental effect to our neighbors over the period of time. We would dearly love the business to improve significantly so we could justify moving out of our home into a conventional office. And that's one of the goals that we have in mind. And we're more than happy to do so when we can afford that opportunity through the increase in our business. And I will also point out that deliveries to our office are few and far between. We also observe UPS trucks and FedEx trucks that are not coming to our home. Now, admittedly, I have to say, I don't have time to go to the mall or many other shopping places. I do admit to online shopping. So on occasion, I do have clothing and books and other things delivered to my home. And unless the occupational, traffic occupation prohibits any vehicle from coming into Inverary to deliver products, our children are still at risk when anybody orders anything and has it delivered from FedEx. It's not my singular employee who's putting you at risk or your children at risk. Now, I understand that the board has the opportunity to apply certain conditions, and as Michael pointed out earlier, we actually have no need of a commercial vehicle, and quite frankly, we would not even need the special exception to be permitted to use a commercial vehicle and park it on our property. We're not asking for many of the conditions or many of the issues that are permitted by right. We merely want to have the opportunity to utilize the services of our employee and the services of an intern on alternative hours, so we will not have the prospect of multiple individuals at our office during the duration of our business. And certainly when our business picks up to justify the incorporation and the addition of other employees, that stipulation is we'll find an office elsewhere because we'll be able to afford it. So, respectfully, I understand what our neighbors are saying. I feel the same way. And quite frankly, I will admit that my husband and I have put a tremendous amount of dollars and blood and sweat into our home, not to devalue the neighborhood, but to improve it. So I don't think what we're proposing here is going to devalue anything in the neighborhood at all. So that being said, I'll leave that to you.
Thank you. Go on.
Swear to tell the truth, the whole truth, nothing but the truth.
Yes.
And your full name.
My name is Georgette, Georgette, Macaulay, Mcauley. And I live at 468 Inverary. The point I want to make is simply this. As residents of a residential community, we all have the right to have our kids visit, to have our packages delivered, as do the applicants. Their kids visit, as residents, they have packages delivered. I think the point is that the traffic and the deliveries are incremental to what normal residences would typically have. And therefore, it's the incrementality that I think is the issue.
Okay. Thank you. With that, I just, coming out of our executive session, I did want our solicitor to summarize a couple things that we talked about. So it's on the record, so you understand, what we use in our debates, and then we're going to have a, hopefully a brief discussion.
This is the summary of the advice that I gave my client, the board. This is a special exception case, and the governing body, the commissioners, have determined that this use is appropriate by special exception. Whether we can't judge the wisdom of that call. They've made it, and we're bound to enforce it. In a special exception case, the applicant has a burden of going forward on, showing the compliance with the various the requirements of a special exception, and that was done in this case. The applicant went through and discussed it. That means that the burden shifts to the opponents, and it's a very substantial burden. And a lot, some of what is said was, is a concern. But frankly, the concern that the applicant will grow in there is an unsubstantiated concern. The fact that the slippery slope, well, that actually has a protection in it because of the 500 feet spacing issue. So as he gets in, that's less opportunity for others. And it is admittedly a first come, first serve, but that's what the ordinance says. And we're not unmindful of your concerns, and but I feel that on this record, the applicants met the burden of what we're allowed to with regard to what we're allowed to decide, and we might, in a vacuum, come up with something else, but we're not in a vacuum. We got this ordinance, and we are required to grant an approval if the applicant has done so, and would frankly be reversed by a reviewing court if we didn't. And so you have to understand the limitations that this board has. In some things we have great latitude, but in others we have to give it even, if, just saying, policy-wise, can we do so or not, should we do so or not, we might not agree, but we still have to give an applicant an approval that he's entitled to.
Thank you, John. With that, I'll open it up to the board for any discussion you might want to have on the application. Any discussion in terms of what we've heard?
Just two things. I want to thank everybody for coming out. Sorry it turned into such a late night, but the board appreciates the patience of people to provide the testimony that they did this evening, and also the detail with which the applicant responded in its application to the criteria set forth in the code. My thoughts are sort of threefold. One was the point that our solicitor made regarding the 500 feet limitation and the implication of that to the slippery slope concern, the limitation as to the one employee, and while I understand the concern about not wanting to be the policeman on behalf of the township, the reality is if a decision is made to grant the special exception and that limitation is breached, I think it will be brought to the attention of the township, and somebody in this situation would be at risk of significant fines. And then finally, and probably most important to me, is that while an awful lot of good points were raised in the comments of the neighbors and the public, so much of it was in anticipation of concerns as opposed to immediate expressions of concerns regarding what they're seeing in the current situation and how it's currently impacting the neighborhood. And the deficit on that point is significant to me in reviewing the case. And I would like to, just because it's clearer for purposes of our process, I'd like to make a motion, and we can continue discussion on a motion if it's seconded. I'd like to move to grant a special exception to the applicants for their property at 447 Invery for the purpose of establishing a traffic home occupation under section 280.115.
Is there a second?
I'll second.
Is there any other discussion on the matter or motion?
Yeah, just a couple things. I think we do appreciate all the comments tonight. But you have to understand, first of all, that we can only react to the application in front of us. So the slippery slope issues, which are, I know they're legitimate concerns, we have to focus on the application in front of us. And as our solicitor mentioned, if someone is entitled under the zoning code to certain use of their property, then they're entitled to that. And if there needs to be a change in the zoning code, that's a different matter. Now, having said all that, there's really two sets of specifications or requirements for this special exception. Number one, there's a set, I think, about 6 different requirements for the specific exception we're talking about. And I feel that they have satisfied all 6 of those requirements. However, there's another overall group of requirements for any special exception, not just for this specific one. And those rules are a bit more fuzzy, not or broader at least. And I think just from what I've heard tonight from the applicant and from other neighbors, I do have a concern for the traffic, because I think that neighborhood is probably more sensitive to traffic issues than other neighborhoods might be. And for that reason, I'll vote against the proposal. But that's all I have.
And without any further comment, I vote in favor of the motion.
Okay. Again, I'm going to echo, I think, Bill's thoughts that, you know, we have a code. It's our duty to uphold the code if the applicant has met the burden. And I would think if you were in their place, you would want us to do the same thing. I, too, was recognizing I think the uniqueness of the fact that one way in, one way out. I think that makes it unique, as well as the fact that the community itself is unique. But again, I think the counsel that we've heard is, you know, it has to be substantial and it has to be occurring. And unfortunately, I didn't hear that. It's great that the community got together to get aligned on this. But, you know, in this chair, we're faced with the code, and the code says you meet these requirements, then you get it. So I'm going to be voting in favor of the motion. With that, I'm just going to take a formal vote, just so we're all getting on the record. So all in favor of the motion?
Aye.
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 Against?
Aye.
The motion's carried. Again, thank you very much for coming out tonight. We appreciate your time. We know it's valuable, and we do appreciate it. Thank you.
Yeah. Yes, of course.
Have a good evening. We'll see you in June. Not you.